May I please, my lord?
Yes.
My lord, with the consent from the other side, my lord, I beg to mention item number 19 and 20, my lord, on behalf of Topizine, PP, my lord.
Okay. 19 and 20.
Yes, my lord.
Okay. So, after
My lord,
Mr.
M. Doji, my lord.
M. You are Mr. M.
M. Doji, my lord.
Your name is there.
No, my lord, I am mentioning on behalf of Topizine, my lord, PP, my lord.
On behalf of PP.
Yes, my lord.
Okay. So petitioner is present.
I am for the appellant.
Sorry, appellant. You are for the
I have no
appellant. Appellant is the applicant in IA.
Yes, my lord.
Okay, Mr. Please name of appearing on behalf of Mr. T. Gini, sorry, Ms. T. Gini, Lanes, additional PP. Praise for adjournment of the matter for
Yes, my lord.
2 weeks.
Today only, my lord.
But today only.
Yes. He instructed me to.
Okay, praise for adjournment of the matter for the day to which the Lana Council for the appellant has no objection. Prayer adopt this matter on Thursday.
Tomorrow, my lord.
Thursday. Tomorrow's list already prepared. It's for Thursday, okay? Oh,
Yes, my lord, I have another item, my lord. Item number 18, my lord.
18.
Yes, my lord.
Yes.
I am for the
In 18 you are for
I am for the petitioner, my lord.
petitioner.
Yes, ma'am. Consent has been taken, ma'am.
Consent taken.
Yes, ma'am.
You are for state.
State, Your Lordship.
Objection?
No objection, Your Lordship.
Mr. Your name is here?
Yes, my lord. M. Doji, ma'am.
M.
M. Doji, ma'am. Reflected M. Margadi, my lord.
Hmm?
Reflected as Margadi, my lord.
Okay. Okay, Lana Council for the petitioner with the consent of the Lana Council for the other side. Praise for adjournment of the matter for 2 weeks.
Yes, my lord. After 2 weeks, ma'am.
Yes, Your Lordship.
All right.
Okay. List is as grateful. Come on, list is matter after 2 weeks.
May I please? Your Lordship, I beg to mention item number 5. Your Lordship.
5.
5, Your Lordship. Kindly, this matter may be examined, Your Lordship.
Hmm?
Matter may be examined, Your Lordship.
The job?
Yes, sir.
This is fixed matter. Yesterday's matter.
No, not
Day
yes,
before
sir.
yesterday's.
No, it was taken up a week before.
It's a different matter, NDPS matter, my lord. Oh, NDPS matter. Yes, you know. Okay.
After 1 week, Your Lordship.
After 1 week.
Yes,
Item 5.
item 5.
And your lordship, and CD may be returned. We have received the CD, so it
You
may
have
be
received the
returned.
CD.
Yes, your lord.
Why? You are not the council, you are council here.
This matter will be taken up by another council.
You are Mr. P. Rajiv.
No, M. Kamcham.
M. Kamcham. Mr. M. Kamcham. You are appearing on behalf of now?
Behalf of petitioner. On
Petitioner.
behalf of, Your Lordship, my name is already there in the Wagala.
Your name is, but it has not been reflected here. Mr. M. Kamcham, Lana Council for the petitioner. Somebody said in the instead case, some other advocate will represent the petitioner who is out of station. Praise, therefore pray for adjournment of the matter for a week. The prayer is allowed. List this matter after a week. Mr. T. Ete, Planet, additional PP is present. Okay, must apply.
Lordship, I beg to mention item number 9.
This is in order. Let us see.
My lord, this regarding CD on the earlier case, CD may be returned, your
Oh,
lordship.
yes.
And updated
In
case.
their case, 5, huh? View of the above. Let the CD be returned, huh? Return the CD, huh? Yes, sir. Okay. 9 what?
9, yes, Lordship.
Obliged.
The leading cause for the applicant won't be able to appear due to his medical condition, Your Lordship. Embarrassed.
Let us see whether the paper.
Whether adjourn after 3 weeks. Your
Okay,
Lordship.
wait for some time. This is in order. Let us see the office now, if there are any records are there. Okay, probably it is ready for the paper book. We may fix it for hearing also. Let us just see. Wait for some time. We'll grant you adjournment, but wait for some time. Okay?
Okay, Your Lordship.
Hmm.
Okay, Lordship. Again, at number 13, Your
13. 13 also. We'll see the.
M. Rangka.
Okay, this is BA.
Yeah, no, this is M. Rangka.
M. Rangka.
Bail application, Your Honor.
Here also.
Consent has been
BA
taken from.
Who is for the state here in item 13? Mr. Ete? Call it. Item 13, who is appearing? Item 13.
Today in all matter I will appear.
Okay. Then here also CD.
CD, Your Lordship, perhaps we have not received the CD, Your Lordship, in item 13, my lord.
Item 13. He is seeking adjournment. Did he need to be returned here also? Adjournment for how many?
1 week, Your Honor.
1 week.
Yes,
Mr.
yes, Lordship.
You are.
Tinana.
Hmm?
Tinana.
P.
Nana. N.
Nana.
Yes, Lordship.
Hearing on behalf of Mr. M.
M.
Rangka,
Rangka.
Planning Council for the petitioner. Praise for adjournment of the matter for a week.
Yes, Your Lord. Yes, Lordship.
We have not received anything, my lord.
Okay. The prayer is not objected. Accordingly, the prayer is allowed. Please this matter after a week. Okay.
Obliged.
Much obliged.
My lord, I beg to mention item number 4. I on behalf of MK Singh. So this matter may be adjourned for today. And list of.
Why in the bail adjournment? Here you have received CD. Okay, Mr.
T by on behalf of MK Singh.
Appearing on behalf of Mr. M. Who? M. Singh or MK Singh?
M Singh.
M. Singh, now counsel for the petitioner. Praise for adjournment of the matter for a day. The prayer not objected. List this matter after a week.
Lordship 2 week.
After 2 weeks.
2 week.
Okay.
Yeah,
Obliged.
TCR is there. TCR already received in this case.
Okay.
Obliged.
TCR.
Yes.
My lord. My lord, I beg to mention item number 12, my lord. My lord, here pleading of exchange is completed, my lord. So on next day, kindly fix for admission here.
Okay, wait
Uh,
for some time.
up.
We'll pass order. Okay. We'll pass the same order, but wait for some time. Oh. Good. Criminal petition allowed
Yes, my lord.
and disposed of.
Obliged.
Obliged, much obliged.
Lordship, this is a civil revision petition against the refusal to take up my appeal by the Inter-Village Customary Court, Kayin. Lordship, I filed my appeal on 12th of May
Appeal
but-
before whom?
before the Inter-Village Customary Court, Kayin.
That is still pending.
Yes.
Then why you have come here?
Lordship, they've refused to take up my appeal on the ground because the EAC has directed them not to take up the appeal since execution is pending before the court
This
of
appeal-
EAC.
Appeal will not lie. And the most what we can do is we can just make an observation to pursue the appeal pending before the appellate lower appellate court.
Lordship, the appellate,
How do we entertain this appeal when the appeal before the Lower appellate court is
Lordship, this is
pending.
a civil revision for direction to the interval is customary to take up a
Revision.
appeal, yes.
But appeal is pending. Your appeal is pending.
Yes, Lordship, my appeal is not being taken up.
At the most, what we can do is we can direct or we can make an observation that to observation you directing you to pursue the matter before the appeal and directing also making an observation that the appellate authority shall expedite the matter.
Yes, Lordship, that can be done with the direction to take up the appeal.
Why they are refusing? Where is the order? Refusal order.
Lordship, they have not passed any order. That's why earlier I'd filed a civil revision challenging.
Have you filed order to take up made a mention before the appellate authority? Kindly take up this matter, like the way you used to mention here, mention memo. Like one small application, this matter has been pending since long. Kindly take up this matter.
No, Lordship, we've approached, but only on verbal instruction.
Where is the application? Have you annexed?
No, Lordship, we've not filed any application, but I've stated in my paragraph 9 why the appeal was not taken up.
Just even see, last month only you have filed this. Last month only.
Yes, sir.
Then when the
Lordship, para 9, I've stated that the matter was not taken up because on the verbal instruction of the ESC. Since execution petition is pending before the court of ESC Kayin.
will dispose of all with that direction. You will pursue the matter before the lower appellate court, and then the lower appellate court will take up the matter and dispose of your
Yes, that
appeal.
can be done.
Okay, with that direction, we'll dispose. Card, Mr.
Jikato.
Hmm. Hmm?
Jikato.
Name?
Jikato.
What, your name is not there.
It's there, Your Honor. It's
It's
second.
there.
Yes.
Okay, G Kato. I thought this. I don't know. What is your prayer?
Lordship, for a direction to take up the appeal.
And then probably in the execution petition, you may have to deposit amount, some amount there. Execution also started already.
Yes.
Then in the execution petition, you may have to deposit the amount. You have taken a loan of 4 lakhs, isn't it? They pass an order for 9 lakhs.
Yes, Lordship.
Then you may have to deposit some amount before the execution court. This is an application filed under section 227 of the Constitution of India. Seeking direction to the Inter-Village Territorial Customary Court to hear the appeal. Has it been numbered?
No,
Filed by the petitioner stroke appellant and dispose it in accordance with law. So, the case of the appellant, or petitioner, is that a complaint was filed by the respondent against him. This might later. Then what I'll do, the rest are taken your name. How many respondents are there?
one.
Full disposal, okay?
Yes.
Pass order,
Oblige.
disposal. Chamber. Yes,
May I please, Lordship?
yes,
Lordship, this is quashing for, on the basis of settlement arrived between the parties.
joint petition.
Yes, Lord. In connection with FIR dated 28/5/2022, Basar PS case number 16 of 2022.
What is the offense involved?
Offense, Lordship, first 354C, voyeurism. Whoever watches or capture image of woman engaging private acts. And
Okay.
then 509, word gesture or act intended to insult the privacy of the woman. And then 66E, IT Act. Punishment for violation of privacy. And 67A, IT, punishment for.
Whether record is necessary? Necessary.
Yes, your lordship, record may be called for your lordship, because since the IT Act is
IT
there
Act
and
is there.
these photographs, and that has to be first assured by this court whether it has been disseminated or not.
Mhm.
And that after securing that, your lordship, considering their settlement,
Mhm.
that this can be considered. So it can be ascertained from the record
Okay.
only. your lordship.
Okay, then, Mr. K. Lole, land counsel for the petitioner. Para. This is an application filed under section 528 of the BNSS 2023. Seeking compounding of the non-compoundable offense registered against the accused petitioner number. Accused is a petitioner number
2.
2.
Lord.
And crossing of the charge sheeted.
Yes, that's it.
Okay, crossing of the GR,
Right.
where
Right.
GR number 21,
Yes.
the crossing of the proceeding in GR number 21, 2023, arising out of Basar PS case number 16, 2022, under section 354, within bracket C, stroke 509 of IPC, read with section 66E, stroke 67A, ITX 2000. Start. Call for the scanned copy of the trial court record. Issue notice. Since Mr. Theatre, Daniel Edison PP, accepted notice on behalf of the state respondent, no formal notice may be issued. Start. List this matter. After when can we list?
After 2 weeks.
After 2 weeks.
Lordship,
So, what is the stage of the trial?
Yes, next date for CC,
CC,
at the very initial stage, yes.
Someone issued.
Someone.
someone already issued.
Yes, your lord. The cognizance, meaning there were cognizance taken. Now
Hmm.
it's for consideration of charges.
Now can stay, I think.
It can be stayed, your lordship, since the settlement is there.
Settlement, okay.
So since settlement is there, it can be stayed, your lordship.
Mhm.
Otherwise,
Fair enough.
later it may be abuse of process.
In the meantime, the proceeding, the further proceeding in GR number 21/2023 under section. Same, huh? Section 354C 509 of IPC with section 66E 67A IT Act. Before the Court of Chief Judicial, Learned Court of Chief Judicial Magistrate, all of shall remain stayed. Okay, till the next returnable date.
Yes, sir. Oblige. sir.
Deeply obliged.
Your lordship takes up item 7, the
Yes.
matter of the prime accused.
Okay,
The public prosecutor was directed to present before this court whether any amount has been sent from the company to my wife.
okay.
My lord, I've gone through the
Because
record.
unless the amount is deposited or transferred to the wife and the rest probably then rest
Your lordship, the interesting
After
aspect is
ascertainment.
there, your lordship.
after ascertainment.
Your lordship, in this kind of cases, the person who commit offense,
Hmm.
they hardly take chance from transferring this amount from the company. Now here.
There is allegation. He has
Yes,
a
yes, that is
specific
there, your lordship.
allegation is there.
The amount of the company has been misappropriated.
Hmm.
Now, your lordship, I have gone through the record.
Hmm.
Interestingly, in many occasions, multiple occasions, the amount has been transferred to the wife. And from wife, certain amount has been transferred to the company. It prima facie shows that, your lordship, why the wife will transfer certain amount to the company.
Why this was to be done?
Absolutely, your lordship. These are the things which have to be thoroughly investigated. Here, your lordship, interesting part is 3 of these applicants, your lordship. Jayanta Das is the brother of the accused. He never made a direct transaction to the wife of the Padma. He made transaction in Padma account. And Padma transfer amount in multiple occasions, my lord. He, in his statement, he has simply submitted that he is a clerk. Now, your lordship, from the record, whether a clerk can make multiple transfer of lakhs in multiple occasions, who hardly earn 50,000 per month, maximum from the company.
No. The third one it says that he's from the statement.
He's a clerk.
He was a manager.
We are saying he's a manager, but they are saying they are clerk.
I have sought instructions, my lord. I admit that I was holding a post capable of making
Manager. You
Yes.
see?
Then prima facie it established he's using his, your lordship, position. He has been entrusted with the certain, your lordship, the property which belong to the firm, your lordship. And he is misusing that property, misusing that amount, dishonestly using that amount for his own benefit. This is the issue here, your lordship. Merely because, your lordship, if suppose there was certain agreement for construction, for other thing, then there will be question of civil dispute, your lordship, that whether there is a dishonest or fraudulent intention was there or not, right from the beginning or not. That the aspect is different. But here in this case, that person is holding a substantial position, the manager. In his statement, he has stated he is a clerk. He specifically denied in his 161 statement that he is not appointed as a manager or he is not acting as a manager. He simply said clerk. Now my brother come with the instruction that he was given an additional charge of manager. So now that person, your lordship, has made multiple transactions to his wife account. Not only from his account, one more co-accused is there, Digonto Bora, his surname alias Dul Bora. From his account also multiple transactions were there, but from the wife account, again, your lordship, multiple transaction has been made to the concerned accused account and to the firm also, my lord. Now, your lordship, we have understand one thing in this aspect, because your lordship is not dealing with a criminal petition and this court is not holding a mini trial.
Yes.
The court has to, it's anticipatory bail, my lord. And recently, your lordship, the Supreme Court has clearly held that when a prima facie case and anticipatory bail is not a rule. It's a privilege, my lord. And the person against whom there is an allegation of cognizable offense.
For example,
Yes.
there is a multiple transaction from the, whether this is farm or company, what is it?
It's a farm, my lord.
Farm.
It's a CG Gojen Gadu Common Service, something is there, a full form. It's a farm, your lordship.
To wife. And then from even, then from wife to farm also. is there.
From your lord, actually from accused to wife and from wife to farm also.
And the proportion is, you have not calculated.
Yes, amount is there, your lordship, multiple, actually approximately
Whether
30.
any in the statement, whether whether the accused has already given statement.
Yes, already,
Okay,
see,
in
on the
statement,
strength of
whether
the.
this has been reflected, why he will.
No, your lordship, that is the issue here, your lordship. What I will clarify, your lordship.
Okay.
Accused has a right to remain silent.
Mhm.
No issue, your lordship. And it has been held by it's a draconian practice that bail should not be objected merely because accused has not testified against himself. But if he refused to give any explanation to the incriminating material against him, then the presumption will always goes against him at the stage of investigation. Because now at this stage, the state has to satisfy this court that more than prima facie material is there against the accused. Now, money is there. One Digonto Bora who used to make transaction to the Padma Bora, and Digonto Bora is hardly drawing salary of 15 to 20,000. He is transferring
So,
multiple
he
amount to
transferred
the
to the brother also.
brother also, and brother make transaction to the wife. And your lordship, this is the interesting part. The offender, they will never make this transaction directly from the farm. But where they have made a mistake, his wife has made a mistake. Actually, it's not a mistake, it's a link for us. But what they have done, my wife has transferred certain amount to the farm. Meaning thereby, it can be presumed that at particular time, there was a question of your lordship regarding the financial audit or any your lordship sitting there in the farm for the calculation of the amount or the fund. At that point of time, maybe for the adjustment, she has sent back
No,
certain
just,
amount.
The accused transferred money from farm to his brother also.
Your lordship, actually, what has accused has done in two way the transaction has been made. One is through CDM, cash deposit machine. Through cash deposit machine, approximately 18,36,900 has been transferred to the wife account of the accused. And the transaction has been made by Dul Bora, who is not before this court, Padma, the main accused himself, and the wife itself. And your lordship, the remaining
How much?
total amount, your lordship, total amount is 18,36,900.
Accused transferred to the account of.
Yes, accused along with one Dul Bora to Josna Bora, wife of the accused.
18 lakhs transfer in the account of.
Wife.
Hmm.
And your lordship,
No, who is this?
and your lordship, wife, the wife of the accused, she made a transaction directly to the farm on 13/6/2024. Now, interesting part is here, your lordship. In his statement,
How
he,
much amount? How
your lordship, 49,500.
Okay, so but in her account it was 18 lakhs.
Yes, your lordship. In his her account, your lordship, 18,36,900. That is through CDM, cash deposit machine, and the total amount transferred to the wife is 38,20,000, my lord.
38 lakhs.
Yes, your lordship. Total, because through it the transaction has been made directly from the account also by this account transaction
So that one go 18 lakhs also transfer
from CDM.
CDM.
Yeah, case deposit machine transfer by what, your lordship. This transfer include Dul Bora, Digonto Bora, who is the friend of Padma Bora, a relative of Padma Bora. And
No, how that is possible? 2%.
Your lordship, 2% Digonto Bora is connected with the Padma Bora, my lord.
Diganta Bora is.
Connected with Padma Bora, your lordship. They both are engaged there, employed there in the farm.
Main accused is.
Padma Bora, my lord.
Okay, Padma Bora along with Diganta Bora.
Digonto Bora alias Dul Bora.
transferred
to Josna Bora account. What Josna cost? Okay. Josna cost.
total 36.
Total amount, my lord, 38 lakhs 20,000. Altogether,
We know that this Diganta is also
your lordship, is there in the statement, my lord.
in the statement.
Yes, your lordship.
Okay, but in the bank account statement, transaction probably it is not reflected. But
Your lordship, the entire bank record, transaction record is there, my lord. This is the
okay.
Jayanta Bora
No,
transaction.
which account it was transferred to?
From your lordship, Padma Bora account as well as Diganta Bora account.
Okay, Diganta Bora account.
Yes, your lord.
In a Diganta Bora account, any amount was transferred by the.
No. From the interesting part, in Diganta Bora account, no money returned, but to Padma and to the firm.
From Diganta.
Yes, sir. Digonto Bora sent certain amount to directly to the Josna coach account.
Okay,
But-
Diganta is not accused.
Yes, your lordship. Now
Because the informant
he's not
has no idea about
he's
it.
not before the court, your lordship. Now this
He's
all
not-
this
not the employee of the.
he's also an employee, my lord.
Okay.
So that is why, your lordship, what we are trying to make submission is that prima facie case is there, my lord. They are not entitled for privilege of anticipatory bail. All this all this has to be unearthed by proper investigation, my lord.
What about anything?
No, the only thing is I'm not a habitual offender. And
Okay.
keeping me under detention, and the lordship has also seen that so much of investigation has already been done. At this stage, keeping me behind bars, and I'm cooperating, I will face trial. I'm there, you call me anytime, I'm willing to come.
Okay, so
And regarding the wife, your lordship, 408 doesn't apply and 120B is bailable. Josna Kosh, 408 doesn't apply, she is not an employee. And
Yes.
120B is bailable in her aspect.
okay.
Oh, bless you.
So just I'll record the name, huh? Mr.
P. Bharadwaj.
P. Bharadwaj. P. Bharadwaj, land council for the applicant,
In both items 6 and 7.
item 6 and 7, no?
Yes.
I beg to place to Jasmine, my lord, on record, my lord.
You are for?
I am for complainant.
Complainant.
My lord.
Okay. And,
I have indicated a parameter. I will not read this, my lord.
in the bail, you are appearing, your name is there?
As an intervener, my lord.
Intervener. Whether your name earlier recorded? No.
No, my lord. My Ukalanama is there, my lord. Ukalanama I have filed, my lord. In the court, there is here, my lord. Whether name is not.
Now, have you filed any?
Authority I have filed, my lord. Authority I have filed, my lord. Ukalanama I have filed, my lord.
Okay. Okay. Otherwise, the state is only the respondent, and you are for?
But I put the item number 8.
Okay, I just. Then
Yes,
I also heard, Mr. The line additional people, huh? Okay. So, anything you want to show anything from the case study?
Your lordship, case diary, your lordship, I have, your lordship, make submission on the transaction, everything, your lordship. And case diary also shows many things. And the statement so far is recorded that they have not given any explanation to the incriminating material. If they have properly explained, then they may convince this court
Yes,
to extend the privilege of absolute bail, which has already been extended to them in the,
Right,
in the
right.
time of interim.
Right.
But say they have simply denied, no doubt.
He has not explained.
Yes, your lordship.
Why the money was to be, money from the farm or the company was
Yes.
transferred in the.
Absolutely, my lord. And that is what your lordship, Supreme Court said, yes, you have a right to be remain silent.
Right.
But if incriminating material placed before you, then you have to give explanation to that.
FIR is clear.
Yes, FIR is there, materials are there. He was given an opportunity of pre-arrest bail. He was before the police. He has not explained anything. He has not furnished any material to show his innocence. And your lordship, I will rely one judgment, and earlier also I have relied, there are 35 or 25, my lord, that the anticipatory bail is not a rule, your lordship. It's a privilege, my lord, which should not be extended against the accused, against whom there is a material, sufficient incriminating material, and prima facie case is there, your lordship. There are 25, my lord. 25, my lord. Actually, this judgment, your lordship, I have relied on the non-bailable warrant of arrest case also. Here, Supreme Court has clearly, your lordship, there are 25. We have already held the power to grant anticipatory bail is an extraordinary power. Though in many cases, it was held that the bail is said to be a rule. It cannot, by any stretch of imagination, be said that anticipatory bail is the rule. It cannot be rule, and the question is of the grant should be left to the cautious and judicious discretion by the court, depending on the fact and circumstances of each case, your lordship. That much, your lordship. This is the, your lordship, the principle on the anticipatory bail, your lordship. One should not come and pray before the court that I am cooperating with the investigation, I should not be arrested. He has to satisfy the court that there is no sufficient prima facie material against him, your lordship, to extend privilege of anticipatory.
So,
I have
this also, my lord, I have indicated the parameter. In similar circumstances, my lord, in similar, I believe, my lord, High Court, different High Court discussed beautifully. The issue, my lord, here is not, and this is not a non-bail application. This is a situation here in, my lord, there is a mass victim, my lord. We family, my lord, as much as 12 family, my lord, in the bars of coming to the road, my lord. Our livelihood has been affected by his intentional criminal act. Now that will be, my lord, will consider, my lord, yes, my lord, like mine in the bail application. Yes.
In item number 8.
Yes, item 8.
Yes, my lord, as I prayed for on the yesterday also, my lord, last occasion, my
So
lord.
this,
My lord,
you
I
get the order this evening only?
yes, my lord. In rest
You'll
of the
get the
item,
order
I am
this
not,
evening.
I have no, my lord, any objection. In the item number 8, my lord, I may be, my lord, allow to 2 days time to, my lord, come with that affidavit. So
This transaction was with
Again, your lordship, from his account also transaction was made to the
Well, but
Padma,
wife of
main
the-
accused, main
I'll
accused.
come
main
with-
accused.
Yes, your lordship. This
I'll come with the
all are
transaction
involved.
detail, wherein it shows that, my lord, the transaction has not been directly made from the company's account. That I'll show your lordship. And of course, my lord, there was a transaction made by my younger brother, who was the manager, the then manager of the company, my lord. And my lord, I have nothing to, my lord, as I have pointed out, I'm just simply a salesman, my lord. Just for 1 year, my lord, I serve in the company. My lord,
Now you are no longer in the
no, my
company.
lord. How transaction has been made, I have nothing to, amount has been withdrawn by my lord, my younger brother. Just, I'm made, my lord, scapegoat in the case, my lord. So therefore, my lord, I'll satisfy your lordship, showing the, my lord, account transaction, how this account has been, the moment amount has been deposited in my account, the same way, my lord, he has withdrawn, my lord. I have not spent the single amount from the company's account or any other person, my lord. Just only, my lord, the account has been, my lord, made transaction, money has been made transaction in my account. So therefore, my lord, I have taken out the account. If it altogether, my lord, the use, my lord, the pages. So this page is not sufficient, my lord. Admittedly, my lord, some transaction has been made in my account, but that has been done by, my lord, my younger brother, Padma Bora, who was the then manager, my lord. My lord, I have nothing to do with, my lord. I have nothing to, my lord, do with the company's, my lord, the transaction, my lord. I am not authorized also, my lord. Just, my lord, to satisfy your lordship, bringing on the records, my lord. My lord, otherwise we are not going to escape. My lord, since we are before your lordship, only 2 days time may be granted, my lord. I'll come with the detailed affidavit, my lord.
My lord, my learned brother has rightly submitted in the sense he said, I have allowed him to use my account. it itself is incriminating material. So therefore, on that expect also it can be dismissed.
No, no.
Yes.
Not,
He knew it, Your Lordship.
my lord, no, I'm not incrementing myself, my lord. What I'm submitting is transaction has been made by my
It was
younger,
under your knowledge.
without my knowledge, amount has been deposited, saying that no, company's amount has already been deposited and I have to buy goods and such, my lord, everything from the companies, for companies. My lord, since it is the management on the part of the my lord, my younger brother, who was the then manager of the company, my lord, I'm nothing to do with, my lord. It is up to the my lord, the manager, up to the company, my lord. I'm just simply a my lord, the salesman. My lord, even I don't have, my lord, I'm not a my lord, the educated person. I'm not a my lord, the literate person. My lord, I don't know about the my lord, affairs of the company if the some my lord, the amount has been transacted, my lord. And-
Clerk is an educated person.
Yes, my lord. So therefore, my lord, few days time may be granted. I'll come with my lord, detailed affidavit showing the my lord, how transaction has been made, my lord.
No, no, my lord, since the other main accused and the wife is, bail has been already been reserved by this honorable court. Your lordship, the prima facie case against him, this is not a trial, my lord, as I've already pointed out. And if he is innocent, my lord, is your lordship whereabout of the Article 22 of the Constitution of India, he will not be arrested unnecessarily, your lordship. Rejection of bail doesn't mean, your lordship,
Unless this
he will
protection
be
is not given, my lord.
automatically arrested, my lord.
Unless my lord, the protection is not given, my lord, the police may arrest. We are apprehending, my lord. Therefore, my lord, we are before your lordship. Had it been the case, then my lord, no, unless 21 is there, my lord, will not arrest. My lord, why should we, my lord, trouble this honorable court?
And my lord, this is
So
the entire
therefore-
transaction, my lord, of in his account. my
The
lord.
transaction, we are not denying, my lord. Transaction, what we are trying to explain before the IO of the case, my lord, before the, my lord, your lordship, my lord, it has not been directly done by me, my
The
lord.
transaction is, okay, it is available with the.
Yes,
Yes, my lord.
It is
with the,
available here, no need to find.
No,
yes,
my
your
lord.
lordship.
It is available here. It
Not
cannot be
all
moved
transaction, my lord.
Because.
I'll show my lord, the
IO
counterfoil also. I'll show my lord, the other account, detail account also, my lord. Only
But-
question of
but
2 days, my lord.
collected everything.
My lord, only question of 2 days, my lord.
My lord-
My lord, showing your lordship, my lord, I have gone through the affidavit filed by the my lord, the petitioner, wherein my lord, all details are not given, my lord. The allegation is transaction
In a
has
case
been
that It
made.
is available. In a case that it is available.
No,
Yes,
my
sir.
lord.
And
The
my
case
lord,
that, my lord, I
this is
may
a
be.
anticipatory bail. Bail is the provision of additional affidavit again. For that, they have to
My lord,
withdraw it
there
and
is-
bring it
there-
to the record, my lord.
There is not always required to be, my lord. It is the practice of the, my lord, the court. If I wanted to bring, my learned brother is making out of the, my lord, the way.
Okay, my lord, then in law, I will argue, my lord.
My lord, let us
Then
argue
let-
on the law
no,
point.
yes, your lordship.
Please.
My lord, I'll argue on the law point also.
No additional material can be considered
No,
by this
there is
court.
no-
It should be come through the public prosecutor, my lord.
No,
How they
it
will
is-
give an additional, your lordship, document at this stage of
Just to bring to the
investigation?
record, my
Under
lord.
what provision, my lord?
There is a provision is not always required, my lord. Out of the making submission is also not correct, my lord. When I wanted to bring some notice, my lord, the records before your lordship to the notice of this honorable court,
No,
my lord,
so, see,
just
for the
don't
purpose-
make a routine manner
for the pur-
argument, my lord,
for
the
the purpose-
objection, my lord.
Consideration of where we call for the case diary, and case diary is there. We'll produce the case diary, and on the basis of the submission and the records available with the court, we'll have to dispose of. Yes, sir.
My lord, what I'm submitting is,
Can you just?
my lord,
Yes, sir.
what I'm submitting today,
Play my,
Yes, your lordship.
the rejection part, huh?
Yes.
my lord, may I afraid it,
Just name and name if it's there.
Name and your lordship, account transaction, everything. I will-
Account
Yes, sir.
my lord,
Mark
on
that.
the last occasion also, my lord,
Yes.
your lordship, my lord, it was the observation, or the view of your lordship, that if accommodation
No,
can
no,
be made.
if it is not there, if it is.
My lord,
not
then in that
available-
case, my lord,
if it is
I
not
may be allowed
available
to,
with
my
the
lord,
IO.
make my argument on the,
Since it is available with the IO, since it is available in the case diary, then what's the necessity?
Then,
of
my lord, in
filing
that
the
case, my
same
lord,
thing by.
matter may be deferred to today, my lord, for my lord, my submission tomorrow, my lord. I'll come with the, my lord, the judgment of the Honorable Supreme Court also, wherein whether the just privilege can be extended, my lord.
You-
Of course, in the unfairity, my lord, this bail application has been applied.
Hmm.
But the person who is not at all, my lord, directly connected with the, my lord, the transaction,
Hmm.
my lord, even another aspect, my lord, he has rightly pointed out one thing, my lord, all transaction has been done, my lord.
Mr.
Everything has
Bharat, what more submission beyond what is there and what is there in the.
My lord, on the few law points, my lord, regarding that, my lord, the
It's
my lord,
anticipatory
investigation, my lord,
bail.
lordship,
Anticipatory bail, records are there.
my lord,
And.
my lord may
records are
kindly
there. On the
appreciate,
basis of the record, this court will dispose of the matter.
my lord may kindly appreciate one thing,
Hmm.
that before your lordship, the IO has provided everything, my lord.
Hmm.
Now, what more required to be investigated, my lord? I'm asking myself,
Hmm.
when the eye of the case is, my lord, the placings,
No,
everything before this
no,
honorable
no,
court,
The record, according to the land PP, additional PP, the record shows something and he is not clarifying.
my lord, therefore,
He's not giving
my lord,
clarification.
therefore,
Because
with
transaction
strict,
in the FIR also, there
my
is a
lord, with strict
straightway-
terms and conditions, my
there's
lord, bail can
specific
be
allegation.
granted, my lord.
There is a specific allegation in the FIR also, there was a transaction.
My lord, transaction,
Okay,
if at all.
in your
my lord,
account and
investigate-
also in the account of the wife. And now he has not given any clarification, neither you
But it
nor
is-
the wife.
my lord, it is
You
the
have
clear,
given an opportunity to clarify yourself.
my lord, it is the clear case of the investigation.
Hmm.
Now,
Okay.
my lord, transaction
Fine.
case,
Okay. I'll dispose of. Okay.
All right.
Next.
my lord, may I pray that, my lord, at least day time may be granted, I'll come with the, my lord, law point, my lord.
What changes you are expecting out of this record?
My lord, when the investigation is almost done, the allegation is
Then
before,
on the basis of that, I'm going to pass order. On the basis of that only,
my lord,
I'm going to pass order. It's not that I'm rejecting you.
my lord.
I may reject, I may allow, but then today
Well,
you'll find it.
My lord, the investigation is nothing, no longer required to be done, my lord. Custodial, my lord, we are ready to furnish everything before it, my lord,
Yes.
eye of the case.
Okay,
Deeply.
three, huh? Three in the chamber. Chamber. Dispose. But then I don't think it will be rejected, huh? Mister? It will be rejected and with the direction to appear before the direction, huh? Yes,
My lord, in my case also.
probably.
My lord,
Your case I'll have to examine.
my lord,
Let me
please.
examine. Huh?
What's up?
Adjourning matter.
Yes,
Lordship, I've already mentioned for adjourning.
yes. So that is why I'm saying that paper book is ready now. It has to be listed for hearing only.
No, no, my lord, here, the
Paper book ready?
Your Lordship, notice was issued and the service has been completed. Your Lordship, it's a POXO matter.
Oh,
So, Your Lordship, victim is need to be represented. Your Lordship, since this is the copy of the service.
not yet received.
Here, Your Lordship, it is step taken through the PP office. It was received by the victim as well as the husband and also countersigned, Your Lordship,
Okay.
for hearing as well.
May I, my lord?
Yes.
My lord, as part of his note date 30/05/2024, the service report to the respondent number 6 to 10 is still awaiting. My lord, matter may be released after 4 weeks.
I'm appearing on behalf of respondent number 5.
Okay. The office note dated 16/6/2025 reflect that the service report in respect of respondent number 2, 3, 4, and 6 to 10 is still awaited in view of the above.
My lord, there is a interim order that may be continued.
Okay, list this matter after 3 weeks. Mister, you are Mister,
I'm on behalf of Mr. Omodi,
and you are Mister
D. Mew, my lord.
D.
D. Mew.
Land Council appear on behalf of Mister O Modi, Land Council for the petitioner, and Mister
Odugong, representing respondent number 5.
Land Council is
Re-
present on behalf of the respondent staff. Okay, prepare list after this thing, the interim order, party first and then thereafter this office note, okay, then this statement after 3 weeks. In the meantime, the interim order passed, earlier shall continue till the next date of listing, okay.
Obliged.
Yes,
Service has already been completed. Your Honor.
yes.
Service is completed, Your Honor.
Okay. Okay, you have taken step by Dusty Service.
Yes, Your Honor.
We filed affidavit,
Yes, Your Honor.
compliance
Fine.
affidavit. How many respondents are there?
Only one,
Okay. Mr.
H. Thai.
H. Land counsel for the appellant. Start, huh? Who submits that after taking steps upon the sole respondent by a Dusty Service, he has filed a compliance affidavit. In the compliance affidavit. In view of the above, in view of the above, the service upon the respondent, however, no one appears on behalf of. Just a minute, huh? When it was, who received?
Pardon, Your Honor.
Is it the respondent himself?
Herself, Your Honor.
Hmm?
Kimala, she is the wife of the
Herself.
appellant, Your Honor.
No, this is somebody else who has received.
No,
Who is respondent? What is the name?
Your Honor, Barmala,
Wow.
she is the respondent in this RFA, Your Honor. Barmala
She is
alias.
the one who has received.
Yes, Your Honor.
Where do we find?
Your, it's just
Identify.
it's in the notice itself, Your Honor. It's in the notice itself.
Okay.
Page number.
Barmala. Okay. Compliance affidavit where the respondent after receipt of the notice has put her signature stuff. In view of the above, the service upon the respondent is is complete, stop, however, no one appears. Continuation after stop, however, no one appears on behalf of the respondent, stop. Okay, then record is ready. Record, whether the record has been received is trial to record. Okay. We'll give one more chance. Okay, list is matter for admission hearing after 3 weeks. Okay.
Keep your pleasure.
Yes.
Yeah, my lord. My lord, I'm appearing for the petitioner, man. My lord, here, exchange of pleading is, my lord, complete.
Okay. Mr.
NUB, man.
Direct counsel for the petitioner. No one appears on behalf of the respondent, although the name of the counsel has been reflected in the course list. Whether record was called for here. Whether record is necessary.
My lord, actually, Oh, and last order, my lord, this court has stayed the impugn order passed by the village authority. My lord.
What is the challenge? The land counsel for the petitioner submitted in the instant case, record of the trial, and the trial court record would be necessary for proper adjudication of the case. So, accordingly, call for the trial and scan copy of the trial court record. List this matter after 2 weeks for admission.
My lord, stay order may be continued, my lord.
Stop. Para. The interim order passed earlier shall continue till the next date of listing. Okay.
All right.
This here, my lord, receive, and this is a joint petition.
Okay.
Pardon me, Your Honor. Your Honor, in item number 11, there was an interim order. It may be continued.
Item 11.
Yes, Your Honor.
11. The interim order passed earlier shall continue till the next date. Okay.
This is a joint petition on the basis of agreement. Lordship, petition number 1 is the victim informant, whereas petition number 2 is the accused.
Just a minute. Okay, petitioner.
1 is the informant victim, whereas petition number 2 is the accused person.
One is the informant. Okay. Who is petitioner? What is the allegation?
This is a matrimonial dispute.
Matrimonial
this-
dispute.
Page 18, my lord.
Just let us FIR, just.
Page 18.
Page number 18.
Yes.
Married.
Yes.
I'm writing to you because I'd like to make a complaint against my husband. I am Srimati,
So and so.
so and so, present resident at Chandanagar, Canada. Since I was the little child, my parents were 10 minutes with Sri Tatam Sanu. My husband married with second wife is continuously harassing me mentally and physically. I was doing a small grocery shop. When I was talking to any person, then
So at that time, my lord, what has happened, because the deputy commissioner has to make certain drafts for the day-to-day affairs of the, my lord, office. So accordingly, she entrusted his one of his staff to make draft. In fact, that draft was her draft, her own draft. It is not for the official purpose. But inadvertently, that staff made the draft without paying the, my lord, these bank charges, draft charges. Subsequently, petitioner has paid bank charges also. She told that it was in my personal, so bank charge is required to be given. So she paid. Those documents are there. At the relevant point of time, thereafter she was transferred and all. So Ministry of Home Affairs initiated my departmental proceeding against the petitioner. At the same time, not against the petitioner, against other person, my lord, an FIR was registered in the state of Arunachal Pradesh in the year 2011. My lord, the departmental proceeding initiated against the petitioner was challenged before the learned Central Administrative Tribunal, Delhi, Your Lordship. Learned Central Administrative Tribunal came to the conclusion that since the matter is in respect of state of Arunachal Pradesh, and state of Arunachal Pradesh is the disciplinary authority. So central government, MHA, has no authority and jurisdiction to, my lord, initiate and proceed in the departmental proceeding. Accordingly, my lord, that departmental proceeding was that order I have annexed, my lord. Against that, my lord, the MHA preferred writ petition before Honorable Delhi High Court in 2019, my lord. My lord, no stay was rejected by Honorable Delhi High Court. After rejection of, my lord, stay, MHA again, since in the disciplinary proceeding, it was held that MHA has no authority, jurisdiction.
So what MHA has done, MHA has written to Arunachal Pradesh and all, and shown, my lord, they have taken the case, that Arunachal Pradesh pending case, to CBI, transferred it by requesting to Arunachal Pradesh government. Otherwise, my lord, as per section 17A, capital A, it is the state government who will refer the matter to CBI, whether they may refer, they may not refer also. And initiated the investigation, my lord. And thereafter, my lord, MHA granted prosecution sanction under section 19 of the Prevention of Corruption Act. That power is also with the state government, because the incident taken place at the state of Arunachal Pradesh. So that proceeding was challenged before this honorable court, my lord, because the prosecution sanction was granted in respect of, my lord, PC Act only. But so far as the other section, like my lord, 477, 420, 409, other section, prosecution section under section 197 is not there at all. Prosecution sanction, that sanction is without authority of law, without jurisdiction, so far as PC Act is concerned. But so far as, my lord, 197 is concerned, there is no prosecution sanction against me, my lord. I am posted at Puducherry, my lord, as a secretary. And now here the proceeding being initiated by MHA, who has no authority, no jurisdiction. When they lost in CAT and no stay was granted against me, my lord, with the malafide intention, this FIR was initiated. May I refer, my lord?
Anyway, but since he need to obtain instruction,
My lord.
and this is, I think, second occasion that this.
My lord.
has been disturbed.
Yes, ma'am.
Okay, let us give him.
My lord, sufficient time may be given, my lord, till then, my lord, I may be, because I am posted
No,
there.
why don't you file,
My
for
lord,
that, why
My
don't you file AB?
my lord, it is already charge sheeted, my lord. I have to appear.
Charge sheet.
Yes, I am praying for staying the proceeding against me before the UPR, CBI, especially the CBI UPR. Today the matter is fixed for granting interim, my lord. This is the last order, my lord. Can you see 3/6/2025? This honorable court specifically instructed to obtain full instruction so that interim pay may be granted. Now my learned friend is taking time, my lord. Till then, my lord, I may be protected, your lord. Issue notice also interim pay requirement so and so. Learned counsel for the respondents shall complete their instruction in the meanwhile and address this court with regard to the stand in the matter. My lord, this is a clear cut case of abuse of the power by MHA, my lord. When they are not my disciplinary authority, they can't sue me. When the departmental proceeding was quashed, while, my lord, kindly see the CAT order, what learned CAT has said, and Delhi High Court has not granted any stay. I'm taking your lordship, it starts from page
But
page
that
220.
understanding of law is, my lord, is still controlling authority is the, my lord, the center, man.
My lord, the state government may recommend, may refuse. It is up to the state. I am one decision of this honorable court, my lord.
Petitioner is IS cadre, man.
My IS cadre. Here also, my lord, your lordship, can you see, here the state of Arunachal Pradesh has refused to give prosecution sanction in Havjor Lowland case. Here the state, it is clear cut case that Arunachal Pradesh is the, my lord, prosecution, they can only grant the prosecution sanction. Here, my lord, he is also IS officer. Prosecution sanction was refused by state of Arunachal Pradesh. Despite this fact, learned court of, my lord, learned court proceeded in the matter. Petitioner approached this honorable court quashed the entire proceeding.
Which court?
It is pending before one special judge UPR. Case number PCA 0000062024. I am praying, my lord, I am posted at Puducherry. I have a small son, your lordship.
No, normally,
My lord,
anyway, we'll give an opportunity to him.
absolutely, my without opportunity, my learned friend, what
But then how do we, since he requested for some time to obtain instruction in this regard, let the instruction,
let him, till then, my lord, I may be protected.
now how you can be protected? Where is your prayer?
Prayer is
What
there,
is
my
your
lord.
prayer? What is your prayer?
Prayer, your lordship, may kindly see.
It is there, my lord, however, my lord, for the ends of justice, my lord, one opportunity may be given.
My lord, page 119,
One opportunity.
on
may
page
be given.
121, your
So that
lordship is pending disposal of page 121, my lord.
Hmm.
pending disposal of instant criminal case, your lordship may receive, please to stay the further.
Further proceeding.
Yes,
That is why he is obtaining instruction in this regard only.
my lord, but my lord, proceeding will initiate. What I am saying, let him obtain instruction. Till then, my lord.
So we'll
in
fix
that
early
time,
that,
your lordship may-
fix early that
my
because
lord, in that, your lordship may- well, till then I may be protected because on the last occasion also, my lord, time was granted and now vacation is coming, your lordship.
Now, the proceeding before this court, before the special judge court,
My lord.
what is the stage?
Charge,
Charge, friend, after the cognizance taken?
cognizance taken, my lord, I have been called, my lord, notice was issued to me, someone
Hmm.
was issued to me, I can't come, my lord.
Next date is fixed for what?
My lord, next date 14th of July, 1/4,
14th of July, for what?
for
Friday
my
after.
appearance and
For
charge.
your appearance.
And my charge. here.
So you was not not arrested.
Why, my lord, why? When the prosecution sanction is invalid, my lord, without.
So that is why the court also will understand. Let him obtain instruction.
If my
Probably
learned
it might also
obtain
come to your
instruction
favor
before
only.
14, before 14, then my lord, I have no problem. After 14, my lord, then in that case, before 14, if my learned friend is taking.
We'll fix after 2 weeks.
Man, I'll come with the instruction.
Date,
Heard Mr. A. Goyal,
my lord.
learned counsel for the petitioner. So I've also heard Mr. M. Kato, learned D.
SGI for respondent number 1, 2, and 4, man.
1, 2, 4, and who is for the 1, 2, and 4? Who is for
5
three?
is the state government, man. Oh, sorry, respondent number 3 is the state of Arunachal Pradesh.
Okay. After Kato, who prays for some time to obtain necessary instruction? Just a minute, Mr. Kato submits that since the office, what office has transferred?
CBI office, man,
Since the CBI office
has been shifted back to the
has
Madan.
been shifted back to Guwahati, he could not obtain instruction, therefore pray for some more time.
Man.
So the prayer allowed. This is matter when?
27th of,
On
27th, 28, my lord,
27 of?
June, my lord. My lord, vacation is there, my lord.
Just a minute.
My lord, vacation is there, I am going out. In
June.
Guwahati, there is a vacation, my lord.
Guwahati
27th,
there is a vacation, but here,
I will prove your
till
lord,
first
but
week,
sometime,
there
my
is no
lord, we
vacation.
advocate should also, my lord.
2nd July,
Well,
2nd July, 27th, I'm saying.
27,
I-
is it okay? I think.
27 is sufficient, my Guwahati, my lord.
Hmm?
It's not that too far.
my lord, again, if inspection does not come, my lord, on such date, my lord, again, it
So
will.
on second also it may happen. Because almost 2 weeks is there, my lord. Almost 2,
27.
27.
Okay, 27. Yes, for comma, list this matter on 27th. Okay.
I go down, review.
Development.
And my lord, that for consideration of interim period, that may be objected.
Man,
Because
On
on,
which date?
on
which date?
27, yes, ma'am.
On which date? The insurance payment can also be
Right.
considered. Okay.
Review.
development.
Okay, hearing the minutes. Okay. So rest will continue at 2. Yes.
My lord, matter may be kindly pass over for moment, my lord.
16th.
Yes,
Yes, ma'am.
Dicky sir is in code 1 and
Legs in
when
court 1.
matter is over.
Okay, otherwise ready for argument.
Yes.
Yes, ma'am.
Okay, time being, huh?
Obvious.
Make appeal, my lord. Here in this appeal, my lord, I am not disputing the facts of the case. Here, the disputing matter is that the income certificate, my lord. So, as per the police report, the deceased, she was a vegetable seller at Kankarnala, and she collected one income certificate from municipal corporation showing that
her income is rupees 30,000 per month. In my memo of appeal 1.3, my lord, page 10, last paragraph. May I read, my lord?
Yeah.
Ordered
Memo, okay, page,
page 10,
okay.
ordered last paragraph. Ordered the claimant present
Page
respondent.
10. Page 10 is,
10,
hmm?
10, 10, 10, 10.
Date.
This is
Page 10 is order.
no,
No.
memo of appeal, my lord.
Memo, okay.
My memo of appeal.
Okay, just a minute.
Interlocutory application, this is state, it is already in front of.
Yes, page 10, what is this?
Yes, my lord, 5.1.3. Ground. Ordered the claimant present respondent in the trial forum below tried to mislead the learned trial forum below, concealing some vital materials in the court. Moreover, the present respondent has miserably failed to submit some of the vital documents before the learned trial forum below. To establish the valid claim case, the claimant ought to have submitted list of defendants.
No, just first, Mr. Dekha, so where is the judgment? An award? Let us see
Judgment and award.
how much was granted.
64 lakh. 11,000
26,000.
or 26,000. So this is exorbitant. Because
Okay,
this is
just a minute.
because due to
So it's a dead case. Dead case or what?
death case.
Okay.
The deceased
So
was the lady,
the deceased was working as
vegetable seller. Vegetable
vegetable
seller,
vendor. Where?
vegetable vendor at Kanpur, Nala.
Ankonala.
Yes,
And then her monthly income was granted
as 30,000. It was taken as 30,000
30,000 per month.
per month. So this was objected by the company that it is too exorbitant because it should not have been pickling vegetable. One cannot earn regularly 30,000. And the income certificate issued by the municipal corporation also.
Municipal corporation.
Yes, Itanagar municipal.
Where do we
corporation.
find? Have you annexed that one? It's in the trial court record.
It is
Whether have you annexed?
It is annexed by claimant only. In the claim petition.
So according to you, this 30,000 per month is exorbitant.
Yes.
The claimant has produced certificate. Claimant has produced an exhibited income certificate. Income certificate was issued by?
Issued by the municipal corporation.
Okay, whether the income certificate was proved? Listen to me.
Yes.
Whether the income certificates are proved? Income certificate,
It was not corroborated in the learned.
I'm asking you whether it was not proved.
It was not proved because
Whether the person who had issued the certificate, whether he was called for?
he was not called for. It was in the lower court.
You probably has cross-examined.
No
The-
cross-examination was done.
Hmm?
No cross-examination was.
Then why you were given opportunity, but were you given opportunity to cross-examine?
Yes, yes.
Then
But in the court below, the company was neglecting because they did not call for.
no. Please Forget about this.
Yes.
Just answer me. You were given an opportunity to cross-examine the person who produced his income certificate.
No, he was not called for. The issuing authority of the income certificate was not crossed.
Please listen first.
Yes.
Whether the person who produced, who exhibited this income certificate.
Claimant.
Okay, whether claimant was examined.
Claimant was examined.
Okay, claimant was cross-examined by you.
Yes,
Okay, let us see cross-examine. What did you ask?
it is in the lower court report.
What it has come out? What came out out of this cross-examination?
They said that apart from the vegetable, she used to sell some ornaments also, local person, local ornaments.
Claimant is PW1.
PW1, husband of the deceased.
You did not controvert the deposition. You were opposite party number in the trial court. You did not ask anything about the salary, anything about the earning income. then unless the earning or the income is controverted, that remains the earning monthly income of income of the deceased. You have agreed that you did not ask anything. You were respondent number
Respondent number 3. In the
three.
trial form.
Three has cross-examined. You asked about the bike. So now, can you raise here? Tell me. The income was not disputed by you. Then what else?
No, only income certificate was disputed.
No, you have not
In that-
disputed. You have not disputed.
Yes, in that court below, because gross dispensed by my predecessor.
Then what was not considered? It was considered only because it was not disputed. That is why it was given. Now, on what basis you are coming? Disputing that which you have not controverted before the tribunal. Now, you cannot say we were not given opportunity to cross-examine. You were given. You did not ask anything. The veracity of about the veracity of the income certificate. Income certificate was issued by one individual. You did not dispute. Then what do you want now? What do you want now? You did not do anything. Now what you want and what way can we give relief? How? Is it possible? Unless you controvert it, unless you dispute the income. I did not dispute, but still you consider giving me or granting less. How can we less? Unless you satisfy the court.
Yes. Here, the claimant was paid before the trial for only 41 lakh, but here 64 lakhs was awarded by the trial court. 41 lakh.
So what? What is your grievance? Where is the claim?
Claim is India's prayer on page 41, man. The opposite party number 3, who is the United Indian Insurance Company, is received. The complainant Sri Balu Laling claiming amount of rupees 41 lakh 30,000 only from the opposite party as compensation on the ground of his late wife Balu Yagan under.
Where are you reading?
It's on the 140.
Hmm?
Page number 140.
140?
Only 41, page number only 41 of my memo of appeal. It is their claim application.
Submission of, this is written statement, 41 written statement. This is written statement by opposite party number 3.
Or written statement.
Oh,
You know, five page number 37. Calculation given 41 percent is 30,000 only. Page number 37.
Oh, 37.
hmm.
Claim.
Claim,
Petition.
in the claim petition, the compensation claim is 41
Like 32. 41 like 30,000, madam.
30,000
Yes,
total.
yes.
Okay, how much was given then?
More than 64.
64 like.
64 lakhs was
Yes.
given
Yes.
against the claim of 41 lakhs.
Yes, Your Honor, it can be. Your Honor. Reason being, Your Honor, that when this claim petition was filed, I think this Pranay Sethi case that was not taken into consideration. So that was after filing of the claim petition, that judgment was rendered. Or otherwise, Your Honor, there's a series of judgment by the apex court says that the court can, the tribunal as well as the court can give award more than the claim amount. Reason being, Your Honor, that we have to find the just and reasonable compensation. So as per the governing law, that more than the claim petition, the award can be granted. I will so those judgment. So at that point of time also,
No, in what it was increased? In what?
40% future prospect. This is after Pranay Sethi judgment. Your Honor, my lord.
This was filed when?
This was in filed in 2017.
I am not
So
disputing
at
that.
that point of time.
2017 Pranay Sethi judgment was already there.
Yes, but 40% future prospect income was not included here.
Okay, but 40% future prospect, that is entitled.
Yes, that's right. So later on, Your Honor, in the interim judgment also this has been discussed. Your Honor, kindly turn to page number 27. Start from page number 26, last paragraph.
Monthly 30.
Yes. Your Honor, kindly turn to page number 26 of the interim judgment. For Your Honor, let my friend to complete his argument, then I will play.
But he is not showing. You have to, this is your case. You have to open your case and you have to argue, you have to submit whatever your claim is. Unless you submit, the court will take 2 days time to go through entire things.
Yes, well, here the claimant claim this was.
But their 40% future prospect was not included. So that is to be
Yes,
included actually.
27 is showing future prospect 40%. It is added, my lord.
This is judgment. This is not my claim.
I am not disputing that, my lord.
This 40% given, yes, 40% is one.
1,08,000. 40% of the annual income.
Yes.
It is given, my lord.
That's why you
I'm not disputing, my.
Okay.
I'm not disputing that.
So the multiply is 17.
17.
This is correct.
This is correct, my lord.
Okay, so the income is 3,78,000 into 7.
These all are okay, my lord. I am not objecting, but
Okay.
only my
Salary.
submission was that
Monthly income.
certificate.
Monthly income, but
Monthly income, yes. Monthly income.
but you did not dispute it before the tribunal. So it remains undisputed.
Yes.
Then how do we change, on what way what is your submission on that? How do you disprove it? How and what way you are disputing this now? You want the court to understand
Yes.
and make a presumption.
Yes.
Assumption. That cannot be. One way in the business, one may earn more than that also. If a person says he is earning 1 lakh, unless you dispute, that remains undisputed. The tribunal has no alternate but to grant it. And accordingly, the tribunal, it appears, has granted.
Okay, my lord. What question is not raised before the trial court? It cannot be raised before the high court means. Maybe.
Then then there is nothing to be interfere with. But in appeal, appeal is a continuation.
Yes. Continuation.
Continuation of the trial.
Yes. So
how do you disprove? How do you dispute?
I am disputing here.
Just a minute, yeah. But this was okay. Your dispute is only with regard to the monthly income.
Yes.
Monthly income as a vegetable vendor, she was only working with some other person.
Yes.
No.
So 30,000,
My lord.
is it not exorbitant?
My position, my lord, is not only vegetable, chicken, vegetable, and ornaments.
No, chicken, vegetable, but this person was in this person who has issued. Who is he? The person who issued this.
His building was taken on certificate.
No. Can that be taken as income certificate? Income certificate.
It's the extra assistant commission. Extra assistant commission.
It was issued by extra assistant commissioner.
Yes.
But whether the extra assistant commissioner who issued, on what basis he issued?
Your Honor knows here in the context of Arunachal
Or
Pradesh.
only on the basis of the declaration made by the party.
Yes.
So that is you say.
Yes. Now,
So
on income, if my friend has concluded, then I will argue.
No, because his limitation
Yes.
as he probably has
Now,
limited grievances against only against monthly income, and he
Yes,
doesn't
yes,
have.
only
He can't so. But then court cannot just blindly agree with that. Also, court also has to satisfy when the person is has challenged.
Now, Your Honor, my case basically, as Your Honor said, so far, she was not only doing this chicken and vegetable, she was not only the seller of chicken and vegetable, she was additionally doing the local ornaments business also. This evidence was brought on record by the person, by the partner also, who was examined as a CW2 in the case.
No, just my question, whether the this certificate, while issuing this certificate, income certificate, so on what basis it was issued, and whether he was examined, the certificate was proved by the person who issued.
Since there was no any dispute was raised, this is basically the.
No, still then you have to you have to actually, even although no question was raised, but then the person who has issued, you should have examined, because this income is not based on on what basis he was issued. He has to actually
This is the
depose before the court.
here in the context of financial policy, Your Honor, because income tax are not applicable. So for the STs concerned. So basically, because this is not even issued under any statutory law, issuing the income certificate. I don't understand there is act under. So basically, what happens in the state of Arunachal Pradesh, this is the practice, Your Honor, that who wants to obtain the certificate, he has to apply to the concerned authority by filing the affidavit, Your Honor.
Yes.
Then thereafter it is issued, Your Honor. So far, this particular certificate is not disputed, Your Honor.
Now, Your Honor, for a while, even leaving aside this certificate, given, Your Honor, so far she was doing business of selling vegetable, chicken, traditional ornament. It's not in dispute. Now, Your Honor knows, the law says, Your Honor, even a person who doesn't do any work, the notional minimum income is 25,000. Your Honor,
No, where?
I have law. If a person is unemployed even, the law says that his minimum notional income will be counted as 25,000 rupees.
25,000, which notification?
Notional income.
Yes,
Now,
notional,
in my case-
notional income, how can be 35,000?
25.
25,
Supreme Court has,
based on what?
no, Supreme Court has given this.
Can you just,
So that.
where?
I will.
Hmm.
Notional income, this is for those persons who are unemployed or who are housewife, basically, Your Honor. I
So
just
that
saw-
used to be based on national income,
Yes.
what the government used to provide at the relevant point of time.
No, now.
And government probably is providing at the time, when the accident took place,
Was in.
Mr. Dekar, when the accident took place, when
Accident took place on 13 May 2020.
22, then it should be 11,000 or
Not
12,000,
2022. It's actually 2015.
15, my lord.
2015, then it would be 10,000 only.
No, I'll show the judgment, Your Honor. I'll show the judgment.
Yes, that judgment.
2021.
Then national income should be 10,000 based on a government notification at that point of time.
No government notification, Your Honor. This judgment particularly has clarified. In view of the judgment, it is a fit case to increase the notional income by taking into account the inflation, devaluation of the rupee and cost. In view of the same, the judgment in the case of Red Light on the land person have not rendered. In view of the individual to take notional income of the disease at rupees 25,000 per annum.
What he was doing?
Housewife, not doing anything. So Supreme Court has deal with those issues that when a housewife dies, we cannot say that she doesn't do any work. The service which is rendered by a housewife has to be respected. This provides a very great service to the family. That's why Supreme Court has said that even for the housewife who doesn't earn outside, for them notional income has to be 25,000 rupees. This is the judgment kindly.
Yes, please.
2000.
I had never seen that.
Yes, Your Honor.
National income 25,000.
Yes.
Normally in Assam it is now probably 7,000.
Para 15.
In Arunachal Pradesh, national income.
Is for housewife.
What we expect is
This is the case of housewife.
para 14.
Para 15 and 16, Your Honor. Para 15. I miss. 96.
What is the notional income?
This is, it happens in such a, this is earlier, a minimum wages used to be paid.
Yes, that is
And-
why
and
what.
the apex court says,
Hmm.
apex courts discuss, particularly some judgments says that this minimum income is not sufficient so far housewife is concerned.
Okay,
Then that apex court says that this is insult to their service, this much of income. So that's why, Your Honor, this 2010 9 SCC, 2010 9 SCC. Apex Court repeatedly directed this central government to amend this schedule 2 of the act, but it was not done. Thereafter, this notional income has been fixed in this subsequent judgment. May I take, para 25 of this judgment, where the service of the wife has been discussed eloquently and has been recognized. Housewife.
in our case, it's not as a housewife.
Our case is, our status is more better.
So,
Eh,
but
eh,
she is basically earning.
That's why.
Doing business.
That's why I'm saying that, Your Honor. A housewife who doesn't, who even if he doesn't work, he is entitled for a national income of 25. Now, my case is, Your Honor, that I am doing the ornament selling, I'm doing chicken, all those things, Your Honor. Then, Your Honor, this much amount, at least 5,000 rupees addition, Your Honor, that at least I am entitled for it. That is the most, I think, minimum income which I have projected in my case, Your Honor. Otherwise, my humble job, Your Honor.
Now see, then the person who works in the department will get less. Who work in the department.
Who work in a department for that, Your Honor, that is something, now what to do? This is how the law has been interpreted.
No, because in Assam also, in so many cases, based on the, of course, the decision of the Supreme Court, this I have never seen.
Yes.
They have evaluated also, and then based on all the judgment of the Supreme Court, it beyond 7,000. The notification earlier,
Yes.
it was in Arunachal Pradesh, 2010, 3,500, then it increased 4,000 plus. Then now it is thereafter 10,000. Now probably it is 11 or 12,000, something like that.
So for
But beyond
housewife,
that, we can't understand what is the notional income.
Yes.
That is the understanding of the notional
Yes,
income,
yes.
minimum wages.
Yes.
So, but here minimum wages, notional income given 30,000, it seems little.
25,000.
25,000.
Yeah.
She has been given 25,000.
No. For my case is that, my case is not the notional income. My case, like.
No. So that probably has not properly proved.
Yes, now I am saying, Your Honor. But then.
No, that's why the court, that is actually has to be proved.
Yes.
That's a person who has issued certificate.
Yes.
Is to prove that on what basis he has calculated this.
Now, so far proof is concerned, Your Honor. Suppose a person steps in the witness box. Oral, because it is not something, let's assume that this income certificate minus this income certificate. Minus. Now, the person, husband, he is in the witness box. Orally, he has made a deposition or affidavit, supported by the person who was the partner in the business. She also made a deposition that we were dealing in the local ornament business also, additional. Because you know, 5 kids, completely wife working, and we only understand, considering that background, how night and day she had to work, and she was providing education to 5 daughters also, Your Honor. Then I think she was working hard and night, and accident also took place because of that one. Because all the time she had to rush, and that time also she was sitting on pillion as a pillion rider for the job, Your Honor, and unfortunately the accident happened. Now my submission is, Your Honor, when the apex court is also acknowledged. Now my case is that, let's say that assuming even if she doesn't earn, even if a housewife, even when the apex court is saying that below 25,000 given to a housewife, this will be an insult to the great sacrifice which the women made for the family. This is where this recognition has been given by the judgment.
This and if you saw this, then the labor person who was working as a wage earner or the contingent worker, all those will claim that he was not in service. Now you,
Now, I
Now
think
count the
better
notional.
not to go for contingency service. This is, but Your Honor, this is a very appreciable judgment. At least we are.
now,
Yeah.
we say that it's a national income, then what is national income? We'll have to be described.
Assumption that we will, the court is saying, assuming that the service rendered by the housewife, the great sacrifice is required for upbringing the family. That's why Apex Code is saying that earlier, the payment paid was minimum amount,
Yes.
minimum. That's why Apex Code, this is an insult to that. That's why I said that we will take it as a notional income, 25,000. So, because I think after direction has been issued. to
Now,
this-
even if this is, even if we assume that this is correct also, and it have to given to the wife, or taken as a national income, then it cannot go beyond 25,000.
Now that's why. I am not giving notional income.
Hmm.
Why I have referred this?
No, no,
Only to satisfy this honorable court. That even a housewife who is in the house, she is in there for 25,000. And I am the working woman who is doing day and night work, Your Honor. I think this is not something I have claimed very exorbitant amount. And I have been looking after these 5 kids, providing schools, all those things, Your Honor, and I was the one who was working. So considering, Your Honor, my local ornaments, Your Honor has to understand, take into consideration our Arunachal context also, you know, how our women does their business, Your Honor. Your Honor knows that, my Lord knows that one. Then my Lord will kindly consider that aspect. So therefore, considering the context of the state, Your Honor, and the local women, how they involve in earning, in supporting the family, Your Honor, my Lord, that this claim of 30,000, my Lord, is the most reasonable income. And moreover, they have not disputed that, my Lord. So, and my Lord will see also, not been granted all the amount which I am entitled.
Which was not granted to you, you are entitled otherwise, huh?
Yes, my Lord, I will show.
As per the
Yes,
pronunciation.
my Lord, I will show.
There you are
I
entitled.
have not been granted this thing, my Lord, but still I have not preferred any appeal. I will show, my Lord. Now, my Lord will kindly turn to page number 27.
No. Page?
27 of the judge, 27, my Lord, is
Hmm.
the judgment.
Hmm.
Now, my monthly income was fixed at rupees 20,000,
Hmm.
3,60,000. Then deduction, my Lord, considering the family, 1/4 deduction was done.
Hmm.
90,000, then it remains 2,70,000.
Hmm.
Future prospects, 40% added, 1 lakh, so and so. Now, annual income comes around this. Now, my Lord will see that as per the judgment of this,
No, I said national insurance company.
as per the judgment of my Lord, Prana Sethi judgment, my Lord. Now, loss of estate, my Lord.
Hmm.
Now, loss of estate, here given only 10,000. But the Prana Sethi judgment says that, my Lord, minimum 15,000 has to be given for loss of estate, and to each dependent, my Lord. Dependents are there. So only, but I have been awarded only 10,000. And my Lord, Prana Sethi judgment again says, my Lord, that 10% has to be increased every 3 years for this particular loss of estate, loss of consortium, this funeral expenses. This is very clear-cut in Prana Sethi judgment. But my Lord will see here in the judgment, what is provided is 10,000, 10,000 and 15,000. But this should be multiplied with, it should be 15, 15, 15. It should be, and my Lord, this loss of consortium as per Prana Sethi judgment be given to each dependent. So if there are 5 dependents, 40,000 into 5, it should be enhanced. Then estate also, loss of estate 15,000 into 5. Then my Lord, 10% increase after every year. Then my whole calculation was, my Lord, it was around 67,000, 45 lakh, something like that. But my Lord, I was not given loss of estate, loss of consortium, not given me. But still I have not put to challenge, my lord. This is what I'm saying, my lord, that I have not been even granted my legitimate entitlement, my lord, in this case even, my lord. So in that way also, I think the insurance company is a profit only. My lord, this has been made very clear in prima facie judgment. And may I make the prima
Yes,
facie
yes.
judgment? Or my
Yes,
lord?
please.
My lord, I'll just take the prima facie judgment. 2017. 2017, 16 assists. There are page, my lord, will find 680.
Just a minute. I'm-
Paragraph take one.
Para 160,
My lord. Yes, my
the
lord.
last paragraph.
My lord, page 710, my lord. There are 710. Let's start from para 52. My lord has got page 710.
Yes,
At the bottom, my lord, paragraph 52.
yes.
My lord, I'll just read paragraph 52 only.
Hmm.
As far as the conventional heads are concerned, we find it difficult to agree with the view expressed in so and so. It has granted 25,000 towards funeral expenses, 1 lakh towards loss of consortium, and rupees 1 lakh towards loss of care and guidance for minor children. The even this figure, it has to increase by 10% every 3 years, considering the price escalation for so many issues. And each of the dependents are entitled separately. But my lord has seen, for me, only I have been given 10,000. And this is a fixed rule because it will not depend on any facts and it is quantified for all the cases. This is a conventional head. And all the subsequent judgment till today is following this particular conventional judgment. There is no variation all over India. But my lord has seen so far this judgment is concerned, my lord, only I have been given 10,000, 35,000 only. my lord. Otherwise, each of the defendants are entitled. In that way also, somewhere, I am at loss, but since my lord, they're not preferred for enhancement event, they're quite just happy what I got. my lord. And my lord, some additional submission, my lord. So, my lord, taking into consideration, my lord, this is a beneficial legislation. Of course, my lord, I cannot make profit out of my lord. Rather, only my humble prayer, my lord, this never has been given to
Now,
me.
see this, supposing if we take this national income,
My lord.
30,000 here in the state, and this will become, of course.
My lord, my argument is, my lord, I am not saying that give me the national income. My only why I have referred, my lord, just to show, my lord, even the person who doesn't work, they are entitled for the 25,000 housewife, my lord. Now, I am referring this since I am a working woman, my lord, and day and night I was working, my lord, with all the burden of the household, my lord. And 30,000 with that, my lord, I was supporting 5 children and I was sending them in a good school, my lord. So that would not have been possible. And my lord, there is, in addition to there is no dispute, my lord, so far my income is concerned. Because 2 witnesses have given the deposition, they were not contradicted, and my lord, the trial court have really emphasized that they have not disputed so far the income of the this disease.
Why you did not dispute?
Lordship. Because my successor
you have
was
any
dealing with
grounds?
this case. So he did not raise any objection in the trial court, for which the trial court was.
What is the ground taken by you? Yeah.
Now,
Since you did not,
my lord,
let us just see it again. What the ground? Just a minute, huh? So tomorrow again, suppose. Let regarding this, he is concerned only with this, but then unable to satisfy the court. Okay? Okay. It was not before. The income certificate was obtained after the death of the deceased.
Yes. After the
After the death.
Mhm.
May I make one more submission?
Mhm.
My lord, this particular case. Now, for the sake of argument, let's take Muslim income. C was not wrong. For the sake of 25. For that, I don't need to prove anything. Now, even if we take 25, I am still at loss, matter, because other heads not given to me. My lord will see if other heads claim, my lord, even if they said now if it is reduced to 25,000 also, my lord can take that fact and still, my lord, insurance is a benefit. Because if I claim other heads, my lord, which is fixed, there cannot be any variation for that. Now, if I claim that one, my lord, then my claim will go around to more than 67 lakhs rupees, my lord. But my lord, suppose even my notional income is taken 25,000. Suppose, for the sake of when we say that she was not working, she was a housewife. Then even my lord, I think this amount and adding my lord this extra amount, my lord, it will be enhanced only, my lord. So, my lord, that's why, my lord, considering this aspect, since I have been deprived somewhere else, almost for more than 3 lakhs rupees, my lord, I have been deprived, my lord. Now, because, my lord, we'll see, loss of estate, my lord, the dependents would have been entitled for 82,500. Then, for loss of consortium,
how much?
2,20,000, my lord. Then funeral expenses, 16,500, my lord. If I add all those things, my lord, that's why, my lord, it is the very balanced way, my lord, because insurance is also not at loss, my lord. Both are in a win-win situation, otherwise, my lord. That aspect, my lord, can take into consideration, considering since this is there, my lord can definitely take judicial notice of this fact, this conventional, heads.
Madam,
Yes.
I agreed with 25,000 notional income. And as for the 2010 9 SCC, it may be considered, madam, but
And then in the rest head, conventional head, it will be,
Yes.
it should be increased.
Yes.
As per the.
as for
capacity.
this case, I admit, because it is full bench judgment.
Fair enough.
I think I will get more amount. I won't claim much from insurance, my lord. Whatever happened, I find
No,
that's why I also did not suggest client to go for the enhancement.
The learned
Because,
friend would have to
we are also
file an
we are
objection
not
if
also
there is
looking
any,
for, my lord, some windfall because of the incident, my lord.
but without filing
It's
an
a
objection.
very just and reasonable amount, my
You
lord.
can't
And they are from the poor family, my lord. They have and 5 children, my lord, and it's very difficult now. And my lord, this is not something, and considering, my lord, today's age, my lord, and my lord, particularly context of Itanagar, my lord, very expensive, my lord. Here, my lord knows like these vegetables even very expensive, everything very expensive, my lord.
And the interest also is given 9%, or what is the interest?
Only 9% given.
9%.
Yes.
Is also.
This is also high.
No, my lord, very reasonable. Because
Hmm.
now apex code is, my lord, till 12% is given, my lord. Why, my lord, I'm
No,
saying?
possible.
My lord, I have
Cannot more,
My lord.
more than bank interest.
no, my lord. I will show my lord judgment, my lord. If
Okay.
No, as per the Reserve Bank of India.
If my lord
present
allows me,
interest
my
is
lord.
only
The highest, the
7.5%.
maximum somewhere, but the most of the case, 7.5.
Five, yes,
My lord.
as
my
per the
lord, there is no fix.
Reserve Bank,
Interest.
it has been already.
My lord
fixed.
will see. My lord, I have a judgment.
Yes. Where is this been that showing 12%?
12%. Yes.
Okay,
I,
please.
I, have, I knew this question would come. That's why I have brought the judgment also.
Because they have raised.
My lord.
Although whether appeal memo, it is there. So
But
tomorrow they will
see,
raise it again.
for this is concerned.
And this you say, the income certificate, Mr. Rajesh.
Yes.
Income certificate.
Yes.
Yes, Mr. Rajesh. So income certificate, actually this was obtained after death of
After death,
deceased.
yes. This is.
Had it been the, supposing during his, whilst he was still alive, if the income certificate.
That's why I said minus income certificate even. It's not, my lord, that's you, my lord, will find the difficulty over here.
So
That
what we'll do?
How to prove, my lord, the oral testimony given in the court that he was earning this much, he was this earning, my lord, that is sufficient, my lord. Even let's, my lord, remove this certificate, even then they have not contradicted those oral deposition, my lord. Now we cannot say, my lord, no, we cannot. There has to be impeached, my lord, that the statement is wrong, my lord. So that stands as it is, my lord, even minus income certificate. So this is my basically, my lord, even without relying on the income certificate also, my lord, that oral evidence is on the record, is in the affidavit, my lord, which has remained unimpeached, my lord. And my lord knows that we don't, because since ST, my lord, doesn't pay the income tax, so we don't have that to show the income certificate. Otherwise, even your I say that even this income certificate is very questionable, because under which act this is issued. But this is the practice what is being done here. By just
Just would like to see the income certificate in the document.
Yeah.
No, this document was, this certificate was issued by owner of the shop.
No. There is one more other. Owner of the shop has not issued certificate. My lord has. That is the certificate that he was doing the business, my lord. There is one more certificate issued by the extra assistant.
Okay, that is exhibit.
My lord will find, my lord.
In exhibit 2.
Yes, my lord. Exhibit 2, my lord. This income certificate was issued before her death, my lord. It was issued in 2010, my lord. And she died in 2015, my lord. My lord, yes.
This is dated 2010.
10.
Mr. Deka.
Yes, my lord.
And
this is died in 2015.
no, then your averment in the appeal, probably appeal memo is incorrect.
This is 52,000. This document, my lord, this is only the corroborating evidence. My lord. What is the important is that what the oral statement made in the court, my lord. This is only the corroborating evidence, this document. It was issued before her death, 2010, 5 years before. And my lord, between these 5 years, income must have increased, my lord, because
There is a, for 35 years,
By that time-
35,000.
My lord, I am not looking for windfall, my lord, as I said, my lord. That's why even conventional head I have not claimed, my lord. And my lord, so far interest is concerned, may I make some submission, my lord? Interest.
Yes, where is the 12%? Can you just show?
Judgment, my lord, will find. Para 41, where Supreme Court has granted 12%. Just I have highlighted. I will make some argument on this point, like how the interest is fixed. Well, section 171 of the MBX says how the interest has to be. There is no fixed rate prescribed. Now that discretion has to be given to the tribunal or to the court. Now, what are those factors have to be considered while giving the interest? The interest, my lord, that long pendency of the case, my lord. And my lord, during that time that it has to be given on case to case basis, my lord. This cannot be fixed, my lord. It should depend on considering the relevant factors like inflation, change of economy, policy adopted by the Reserve Bank of India, and the injuries, permanent injuries suffered by the victim, sufferings faced by the family members, all those aspects are there. My lord, will see here. I have not been given interest from the date of filing of the complaint. That is also one thing, man. I have been allowed interest from the date of the award. But basically, my lord, it has to be
It is
awarded
from the date of the award.
filing
From the
of
date of
the
the award.
Yes,
Date
date of the
okay.
award.
Not from the date of
No claim, my
filing
lord.
of the claim.
I have also so many grievances, but since I have not, my lord, can
No,
we
this is this
page number 28?
This interest was given based on because for 22 years they were pursuing
Yes, yes.
and that was not granted and
Yes.
it's like
That's
a
why I said,
penalty.
my
It's
lord,
like a
there is-
penalty.
Yes, sir.
Yes.
I said, my lord, there is no fixed thing.
No fixing.
It depends.
But
My lord,
then-
can
but-
turn to page 28, my lord.
This.
No, no, no. This petition, just to show that from the date of award only I have been given, my lord. Page 28. Page 28, my lord, has found. Award, number 9, my lord, at the bottom. The order amount shall carry in interest at the rate 9% per annum from the date of its award. Then this award was issued in 22. Accident happened in 2015. I've been pursuing the matter since 2015, my lord. Once I was filed, and because of some technical effect, it has to be withdrawn. Again, it had to be filed. For more than almost for my lord 6-7 years pursuing the matter, my lord. And this 7 years all back that no interest has been awarded. Here also, my lord, somewhere I am at loss, my lord.
Now if Mr. Dekar, if they find counter objection, then
My
you will
lord,
be loser.
I have so many things to get. But since
But then this
I am very,
whatsoever may
we are also
income.
happy whatever we have got. And we are not-
income for the
I'm
non-working.
admitting my friend's 25,000 national income.
Okay.
Then you give me
2010 9 SCC.
Okay, just a minute. Then what we can do this on the consensus this is just proposal. Monthly income bring it to 25,000.
Yes.
Will not touch upon the deduction future prospect Laws of estates will give the, as per the pronunciation, 10 will increase to 15.
Yes,
Laws of consortium, 40,000.
yes, no problem.
Okay, consortium from 10 to 40,000.
Yes,
To each of the my lord dependent.
It will be each only.
Yes, my lord. There are
It will
five
be-
dependent. It will be
It will be
multiplied.
40,000 each to the all the dependent.
Yes.
Into how many? How many?
Five, my lord. Four children. One.
Father is not allowed. Father is entitled.
yeah, not entitled.
Father is not
Father
entitled.
is not entitled.
Yes.
Not dependent.
Then four,
Four.
I will be confined to four, my lord.
Into 4. Funeral, I think is
It will
as per-
remain as it
it
is.
will remain as it
Yes,
is.
please.
So this way we'll settle them. Interest will remain as 9%. Okay, it won't make much difference. Letting
I
also
will get
succeed, you'll,
I make
you'll,
it more.
you, yeah, you, without filing any counter objection, you will succeed in. And then he will also at least 5,000 in the month.
My lord, my lord.
Deduction. So that way, what we'll do is, this calculation will be made. It will be recalculated and then modified accordingly.
My lord,
Okay?
my lord,
To that extent,
yes. My lord, may I submit?
yes.
In this instant case, 50% of the awarded amount has already been paid in advance.
Then rest will be.
Yes, yes,
you
it
pay.
will be-
Where to deposit? Where it was paid?
It was paid before the registry only of this court and
Registry of this court, they have already withdrawn.
Yes, my lord. We have.
yes,
Okay, then
And-
after this calculation, recalculation,
yes,
after deducting the 50% which have already been deposited, after the total calculation will be now
yes,
different.
my,
Figure will change.
yes.
Out of this
statutory-
figure, whatever you have already deposited and withdrawn by the appellant,
Yes, ma'am. But
and
statutory
rest
deposit-
of the amount you deposit.
Yes, statutory
Within
deposit
the
rupees
rest of the
25,
statutory also will be
it
adjusted.
will be adjusted.
Just a minute. Huh?
Yes.
Relax now.
Yeah, note this one. Okay. Then just only this one. Only heard Mr. U Deka, Land Council for Appellant. I have also heard Mr. R Sonar, Land Council, appearing on behalf of the respondent claimants. Stop there. Rest all this good, but yeah, the amount. The final monthly income rupees. Would be 25,000. Right, one, high monthly income rupees 25,000. There. And then the deduction for 1/4, that is 90,000. And 1/4, 1/4. Don't say 90. 1/4. And future prospect 40%. Actual income, okay, that will change. Loss of estate from 10,000 to 15,000.
50,000 multiplied by four, my lord.
Multiply by 4.
And my lord,
Loss of consortium,
40,000.
rupees from 10,000 to rupees 40,000.
Multiply by five.
Into
Four.
4.
Multiplied by four.
Okay. Expense, funeral expenses.
15,000.
Rupees 2,000.
My lord, here one thing, Pranay Jaswant says that every 3 years, this conventional head, 10%.
That they will count. They will count
My lord.
according to the pronunciation. But this was also granted for the. This was also granted as per the pronunciation only. It
Which
appears.
one, my lord?
No, this award.
No, my lord. My lord will see.
See, just
Loss of
page
estate.
20. but referred, but then no property given.
No, yes, referred by my lord, that's why I said my lord. Laws of the state, 10,000, my lord, how it came, my lord, 15,000 into 4 dependent, my lord. Then consortium 40,000 into 4 has to be there. If we exclude father, my lord.
Can both party calculate this, because this, now we know
Yes,
the
we can
changes.
calculate, my lord. Now it's, I
Calculate
can
it and give it,
my lord, I can-
both,
yes.
put a just initial and
Yes,
give it
yes.
to the court. Okay.
Yes, madam. Calculate and provide.
Calculate, just allow him also to see,
Madam.
and then put initial of both the parties. Okay. Kindly note it, this one A, page, kindly open page 27 of the monthly income would be from 30,000, it will become 25. Huh?
Yes, madam.
Deduction will remain same, future prospect will remain same, actual income that also will change now. Loss of estate will become from 10 to it will become 15,000. And consortium, then 10 will become 40 into 4. That also 15 into 4, okay? And then funeral will remain same. So these calculation, just both calculate it and then just in a type copy also, okay, by tomorrow,
Yes, madam.
okay?
Okay, the question, my friends should not tomorrow deny that if it is more, more.
No, the court is still there. Then it will be, next para would be, the awarded Thirteen 5/2022. Which is modified to the extent as indicated above. Stop. The next point would be the insurance company has already deposited 50% of the total awarded amount before the registry of this court. What was the amount? What was the amount deposited and received?
Half of the.
No, half. What is the amount? No, half. Now the amount will be calculated because that amount will be deducted.
Madam, we will make the accordingly calculate. and we'll
Okay.
give you.
Okay. Deposit and to which the to which the respondent has already withdrawn. Okay. The insurance company is directed to deposit the remaining amount before the registry of this court within how many
Well, 45 days will be required because it will be sanctioned from the.
okay 45 days
Yes,
within
45 days.
45 days 1 month, okay 6 weeks 40 within 45 days huh?
Yes.
Okay, before the registry of this court staff. And then the next point would be the statutory amount deposited by the insurance company at the time of appeal shall be adjusted and will be withdrawn by the respondent, claimant. Okay. Your deposition, while depositing, so this 25,000, will you assume that it was, it has already been deposited?
Yes.
Okay, 50% plus 25.
Yes.
25,000.
Yes.
Okay. Okay, so that way, dispose of.
Madam.
That's fine.
Okay.
And more point, the factum of the court, the factum of the case, not disputed. Okay, the only then is let it. This will elaborate. This is a reserve. See. This was 15.
Yes.
16. Okay,
Wait, wait.
no. This was 7. Okay.
Mr. Second appeal against an order was by
Hmm?
the second appeal, my lord,
Yes.
against the judgment passed by the learned first appellate court.
Yes. Okay. Just a minute. huh? Yes.
The substantial question of law involved, my lord, is
Hmm.
whether the substantial questions have been framed, my lord.
Yes.
Yes. Now the first appellate court entertained the appeal without there being any condonation of delay application. Secondly, no decree was challenged before the first appellate court.
No.
Decree was not challenged before the first appellate court. Though in the petition it was written, the decree was not filed. It is settled law, my lord. Appeal is against the decree, not the judgment.
When the substantial question was framed, on which date?
There is order dated 8/12/2021.
8/12,
Yes.
2021.
Yes.
What else? Out. Okay, so the appeal was not accompanied by the countenance delay petition,
Yes.
and the
Decree was not,
decree
never
was
produced.
also, okay. Otherwise, the decree was drawn after the
Yes.
decree
Decree
was
was
drawn.
drawn. Decree was drawn.
Okay.
I have annexed it.
Hmm?
I have annexed it. Decree was
You have
drawn.
annexed, okay.
Decree was drawn.
Remanded. From the to the suit. While the credit was independent. What is the second issue? Substantial question issue. Question second one, second substantial question. Rightly, it was remanded.
Yes, remanded back.
No, I think we have to go, I need to go through the judgment then.
Yes. Impugn judgment, my lord.
The earlier judgment also, I think the first judge,
First judgment.
you just agree because I haven't seen. I haven't gone through. So that is why I need a brief of the entire case.
Yes. Facts are a bit longish. The plaint was actually instituted. There was some dispute, my lord, regarding the respondent's lineage.
Before, initially it was filed before?
Before the civil judge senior division.
Civil judge senior division.
Yes.
Who filed?
I filed,
Okay, so then,
challenging his identity,
challenging his,
my lord.
this is regarding,
This is regarding, my lord, his legitimacy. My lord, it happens in Gallo society, my lord. We have earlier this concept of that
Yes.
type of thing.
Yes.
So he produced an affidavit, sworn an affidavit saying that I am the son of this person, Bogo, original claims.
okay,
So I challenged them.
okay,
So that was decreed in my favor.
just one,
Yeah.
let us see the prayer in the,
Initially it was filed before the district judge. In 2000, it was ultimately transferred to the after the.
must have annexed,
Yes,
no, okay,
at page 27.
27 is,
Page 27 of the memo. No,
minute, huh? In the year 2010.
10, yes. This was initially before the district judge.
Hmm. Before the district judge, Basar, okay.
Yes.
Um,
This was under Order 32A, Rule 12B. Declaration as to legitimacy of a person. Legal points are short, the facts are a bit longish.
Facts are long.
Yes.
Can you just insert?
In
So
short,
this was
in short,
filed by
in short, it will be difficult. man.
plaintiff, huh?
In short, it will be difficult. In short, legal points is settled.
Because the background I just wanted to know
Yes, yes.
actually.
If your lordship may kindly have
No, this is,
this,
both are male,
my lord.
the plaintiff and the
Yes, yes.
defendant.
Yes,
Both are male person.
yes, yes.
The brother or what?
No, no, we are saying he's not a brother, he's not Bobo, that is the case. We are saying he's not our brother. He was born to I don't want to use that word, my lord. Earlier, your lordship knows we had this Galo customary practice, this and all this slave types, that type of thing.
So your allegation
We are
is that
saying
he was
yes.
not born.
Yes,
He was born to that.
yes.
Okay. This is your,
That is my claim. So this is my
this is
claim.
your plaintiff here.
Yes.
Okay, then, just a minute, huh? Let us see the prayer.
Page 38.
What record was to be called for here in this case? If it was the first one.
Call for the record, my lord, it says they just write it.
Okay, question set aside, a decision taken, something. What decision was to be?
That is declaring him as part of the Bogo clan.
Okay. So, and then by declaring him as part of Bogo,
Clan.
what adversely affect you?
Because he is not part of the Bogo clan.
Okay, so if he is declared as a part of Bogo clan, what will affect you? Because you must have agreed.
Yes, because
Declaration.
Galo, we have a system of life.
Okay,
How we
only
have
objection that he is not a part of it.
Yes,
Okay, your objection is only
yes, yes.
to that. Okay,
Yes.
stand.
But the issue with your lordship is second appeal, my lord.
Oh, no, I just stand. So thereafter,
Thereafter, my lord,
just a minute, of course, we said to say the decision that is right about. Okay, so you, that he is part of is, you want that order to be quashed.
yes.
Okay, so thereafter, where is the decision on this?
Of the, my lord,
Yes, yes.
civil judge senior division.
Civil judge senior division. It
That your
was,
lordship
it was subsequently transferred to the civil judge
Yes,
senior
yes,
division.
yes.
Okay. Where is the,
Page 76.
is the judgment in this?
Yeah, this is the decree first one. 76 is the decree. Judgment is started 78.
'78.
Yes.
So these
The decision,
71, these are just orders in the in between.
there are various orders, my lord. Since this is a second appeal, I am not bothering your lordships.
Okay, okay. So 70,
6 is the decree, 66, 77. 78 is the judgment. The
claim for declaration.
decree, your lordship may kindly have a look at page 76. Page 76, the decree. 76, man.
Yes.
This suit coming on this day for final disposal before civil judge senior division Alo in the presence of such and such. In view of the decision arrived at in the issues of the present case, it is declared that the present suit is decreed in favor of the plaintiff. The defendant is restrained from giving effect to the alleged affidavit sworn by the defendant on 02/11/2009. The decision passed by the dated 21/2/2010 passed by the Gaonburas in the residence of the defendant and 22/2/2010 passed by Gaonbura and other null and void and is illegal. In the same are set aside. Defendant Deso Bogo declared as son of Dedak Bogo and Raper Bogo. The present is disposed of with cost.
So
Dedak Bogo is his actual father.
actual father with, okay. So this is the judgment.
So this is the decree in my favor.
Okay, so against this, they have filed.
An appeal at page 104.
Just a minute.
This was time barred. This is the bill. Page 121, my lord. Is my written objection, written argument.
Just a minute. In this appeal, let us see that here is the prayer.
Prayer is to say, my lord, set aside the judgment and decree.
Judgment, it said judgment and decree.
Yes. So in the prayer, it says judgment, decree, the judgment. Prayer at page 117, my lord.
117.
At 17.
Yes.
Under the above facts and circumstances, it is humbly prayed that the honor may be pleased to admit this appeal petition and call for the records. The board parties, after hearing, your honor may be pleased to pass order setting aside and questioning the impugned judgment that is such and such in respect of title number such and such. Even the prayer itself says only judgment. And
Okay,
in
the
the
decree was
drawn up
passed on.
on the same day as the judgment.
Okay, so on the same, the decree was.
Yes.
also-
8/11, 8/1, 18. Even in the cost title, you also will find the decree is not mentioned. At page 104. My written argument is at page 121.
121.
Various arguments, but I am not be relying upon all of them.
4, 5, and 6 are relevant. My lord. Yes, paragraph 4, argument 4, 5, and 6. Paragraph 4, 5, and 6. I say the instant appeal is barred by law of limitation. The Ladakh Trial Court passed a decree on 8/1/2018, but the instant appeal has been presented on 11/5/2018. Act provides the period for any decree under CPC shall be 30 days from the date of decree or order. As such, the instant appeal will not be preferred within 1 month from this time barred. So this is my first argument. Serial number 5, memorandum of appeal is not accompanied by any application for condonation of delay. Then 6, my lord, decree passed by the Ladakh Trial Court not challenged. Rest, my lord, may skip. Now your lordship will have the impugned judgment at page 126. (126) is the impugned judgment. It starts from 100, relevant portions, my lord, will start from 140. 30, sorry. I'm just reading the argument made behalf of the respondent there, the appellant here. Mr. 130. 130, paragraph 5. Paragraph 5. Mr. Sasan Sach, learned counsel for respondent, plaintiff, advocated the impugned judgment and decree containing inter alia. The appeal is not maintainable in law as well as in facts. He urged upon to dismiss the appeal at a threshold it is barred by law of limitation, categorically opposing the appeal preferred to the provisions of section 9 that there is scope for appeal against judgment, sir. As the member of appeal is present, petition does not challenge the decree drawn in the contested suit. I have carefully perused the records available before this court. It is found that the memorandum of appeal does not mention about decree. So even the first appellate court admits it. Be that as it may, the defective per se should not be the only reason to dismiss it. Civil law as such is dynamic and very vast. All the pleaders are not placed in equal situation in terms of accessibility to law journals. With great respect, my lord, that cannot be a ground. Books and exposure to variety of legal branches pertaining. So the learned first appellate court has allowed it even without a degree on the ground that all the lawyers have the requisite knowledge. Can that be a ground? So this is the ground. And as far as limitation is concerned, my lord, page 134. Paragraph 12. For the 134. For the purpose of computing limitation, time periods for appeal against decree is 30 days. And limitation runs from the date of decree of the suit. Be that as it may, the orders recorded on 15/5/2018 and 29/18 of the present nowhere indicates any objection having raised by the respondent plaintiff during first and subsequent hearings on appeal. In the circumstances under the Provision Section 5 Limitation Act, it is inferred that the delay of 90 days taken in preferring this appeal has been condoned. This is the ground. It is inferred just because nobody has objected to it. I have a direct judgment of the Honorable Supreme Court that says a memorandum of appeal without an application of condonation of delay, even if the party does not raise any objection, has to be dismissed. So these are the two grounds. Admittedly, no condonation application, no decree. I'm not bothering you too much, manner, since it's a second appeal. This is 1960 SCC online, reported in AIR, my lord. AIR citation 61 SC 832. Paragraph 5. Is to be preferred in the form of a memorandum signed by the appellant or his pleader and presented to the court or to such officer as appointed in their behalf and accompanied by a copy of the decree appealed from. Decree. And of the judgment on which it is founded. Rule 1 empowers the appellate court to dispense with the filing of the judgment, but there is no jurisdiction of the appellate court to dispense with the filing of decree. No jurisdiction. Where the decree consists of different and distinct several directions enforceable against the same or several defendants, the court may permit the filing of such portions of the decree as are subject matter of the appeal. But that is a problem with which we are not concerned in the present case. In law, the appeal is not so much against the judgment as against it. That is why Article 156 of Limitation Act prescribes a period of 90 days for such appeals and provides that the period commences to run from the date of the decree under appeal. Therefore, there is no doubt that the requirement that the decree should be filed along with the memorandum of appeal is mandatory. And in the absence of the decree, the filing of appeal would be incomplete, defective, and incompetent. Clearly, the decree was not there. On limitation, my lord.
This is 1960.
Yes. SCC online. AIR citation is my lord, AIR 1961 SC 832. I am given to understand the library has already started shifting, so I bought a printout from the SCC online.
Okay. This parallel is AIR.
AIR 1961 832. Paragraph is same, paragraph 5. 832.
2.
Yes.
Para?
5.
Okay. Same.
This one is on my lord. This is 2008-14 SCC 445. This is on my lord delay. My lord will kindly have page paragraph 31. Paragraph 31, ma'am. Yes, my lord.
Yes.
But even otherwise, according to the council, if the application was not within the period of limitation, the so-called concession would neither bind the bank nor invest jurisdiction or power in the authority to entertain such application, which was barred by limitation. In other words, according to the council, the concession was against the provision of law, which would not bind the bank. Now, limitation goes to the root of the matter. If a suit, appeal, or is barred by limitation, a court or an adjudicating authority has no jurisdiction, power, or authority to entertain such appeal, such suit, appeal, or application, and to decide it on merits. Paragraph 33. Section 3 of the limitation reaches under. It has been quoted. Bare reading of the aforesaid provision leaves no room for doubt that if a suit is instituted, appeal is preferred, or application is made after the prescribed period, it has to be dismissed, even though, I will kindly note this, even though no plea has been raised or defense has been set up. In other words, even in the absence of such plea by the defendant, respondent, or opponent, the court or authority must dismiss such suit, appeal, or limitation if it is satisfied that the suit, appeal, or application is barred by limitation. So the ground that there was no objection raised on the earlier two occasions, that cannot be a legal ground. It was incumbent upon the first appellate, even without anybody raising any objection, to dismiss the appeal, with being time barred. Admittedly, my lord, the finding itself says there was no decree and there was delay. The appellate court itself says so. But he has given some decree, he says, the lawyer may not have the requisite knowledge. With great respect, my lord, that cannot be a ground. So these are the two settled laws. Decree has to be filed along with the appeal, and if there is delay, it has to be condoned. Otherwise, suit or appeal has to be. So these are the settled laws. So on that, my lord, second appeal, whether second appeal can be entertained on such point, my lord. This has also been reported, my lord. I'm sorry, I bought it from the Supreme Court website. This has also been reported now. Page 16.
This is on?
This is on the second appeal. What is a substantial question of law? Paragraph 37. 37(3), my lord. Subparagraph 3. Page 16, my lord.
Yes.
Paragraph 37, subparagraph 3.
3.
A substance,
Hmm.
a substantial question of law will also arise in a contrary situation, where the legal position is clear, either on account of express provisions of law or binding precedents, but the court below has decided matter either ignoring or acting contrary to such legal principle. So, my lord, supposing the Honorable Supreme Court has already set the law, and if the appellate court or the trial court acts contrary to that precedent, then also a substantial question. That is also a substantial question of law. Here, the settled law is decree has to be there, and on delay it has to be dismissed if it is not condoned. So these are settled principles of law. The first appellate court has acted contrary to that. So it is a substantial question of law. That is my humble submission. The judgment passed by the first appellate court is bad in law, being contrary to the settled position of law led by the Honorable Supreme Court, as well as the statutory provisions actually. You have settled that judgment lies against decree, not the judgment. That is my humble submission. And that is the only thing my learned friend has to answer. Whether the decree was filed or not. The judgment itself reflects there was no delay application and there was no decree. Paragraph 5 and 12. That is my humble submission.
Yes. Yes.
As for the contention raised by here is a two substantial question of law. One is condonation, another is remanding the matter then to that. We will just Indian that is the issue raised by the appellant. I have to say on this whole law point, before that coming into that law point, the issue is yes, there's already a fight matter. This is human dignity, because in my affidavit in opposition, I have this right issue
That is a fact.
yes. This, in my written argument, and this is the legitimacy of the person. My this lineage has been linked with this, one person called a slave of this Bogo clan. Whereas it is a disputed slave, which is which one to be tried and decide on the basis of lineage, basis of lineage. That is decided. And this case is being raised on technical issues, and matter has been cancelled before that. What has happened is a trial court that has been seen. That manner in which trial court has lead the case, that can be understood from this judgment. Can you see? Judgment is completely conclusive. My
Minor, we are on second appeal matter.
Yes,
That's
that
the
is-
crucial-
Yeah, that is why he is.
even the
fact.
and before that is to be understood. Page number 34 of my activity in Assam. Judgment passed by the Hotel Legal. In this case,
Just a minute. Page 34.
page 34 of my affidavit in opposition. Not the appeal. Appeal is for
Yeah, file affidavit in opposition.
my affidavit in opposition.
Okay.
Issues all resolved. In the judgment, if this honorable court see that this all judgment in detail, read in detail, then will be understood. Because fact is that this man, as per this margin of this correspondence side, he says there was this father, fostering father is Dede Gogo. Because fostering, he was having fostering father because his father has died. That is why died at a young age. His mother married him. At that point of time, this person was respondent was in the mother's womb. It is as per the statement of all those village people.
This is.
Who knows the fact?
Just a minute. This is the 30,
Order
page
passed
34 is.
Page 34 is order passed by,
This is the impugned judgment.
yes, impugned judgment. Impugned judgment passed by the district judge. Question. This is the currently put under 7.
Okay.
Report is coming to this point. I need to explain it. Number one, point raised by issue raised by this appellant is aware of the no limitation. I see in my appeal, in the page number here. In appeal. Page number 10.
10 of.
Kindly see, we can go by the appeal petition. Appellant.
Okay.
Page number 104, para number 10. 104, paragraph number 10. You can understand.
Page number 10.
104, paragraph number 10. Why this honorable that appellate court has admitted this appeal, saying that this is not barred. Under what circumstances that has been allowed? Kindly say paragraph 10.
Para 10, this is this
Paragraph 10 of
application or this is appeal.
yes, appeal, my appeal.
Before the
Before the district assessment judge.
Okay. Paragraph
Paragraph
10.
yes, 10.
Yes. Yes.
That may I read the content?
Yes, please.
The judgment copy was received on 17 April 2018. That of receipt from the Court of Civil Justice Senior Division West here, Alabama, as said, this appeal petition is filed with the case, which under limitation time. Hence, no limitation doesn't bar.
Because what happened, the background fact is that order was that the impute that the degree passed, the judgment passed by the civil judge senior division.
Just a
was
minute, the judgment copy was received
on 17th April 2018
from the court of the civil judge division.
from the civil judge senior
This appeal
division
petition was filed within 30 days.
within 30 days. I have filed the appeal before the district and session judge within 30 days. That is within the period of limitation. That is why honorable learned court has allowed my appeal.
No, whether like in the high court, whether in the trial court, the registry, is it or is it not the duty of the registry to check whether the appeal is barred by limitation? or not?
Limitation is counted from the date of decree, not from the date of receipt of judgment. Cannot be.
Okay, no. So is it or is it not the duty of the registry or to check whether the appeal or the petition, whatever may be filed before the court, is barred by the limitation? That is the first question.
Yes.
Normally is to be taken up, but so
Yes,
in
I
the
don't know
present
that.
case, it was not rejected in the.
It appears so.
It was not rejected.
It was but without considering that it was placed whether the limit is barred by limitation or no. So it was straight away placed before the trial court,
This
appellate court. So just a minute, huh?
one of the substantial question of law is limit.
Hmm.
So this matter has to be settled whether there is a bird by limitation or not. That is the one of the prime issue here. This I have to say, as per the observation of the landed court of district and session judge. Also saying that this, and we have made specific environment in the appeal that although the judgment was passed, judgment was passed by the civil judge senior judge, it was not passed often court. No advocate no. When it was passed, and there was no pronouncement saying that it was kept in this courtroom. Nobody knows. And later on, we inquire about the matter. We have been told that.
How can this be allowed? And yeah,
We have been,
these are
not in the high court. I'm saying that, but it happened. Let me submit first. It was the case. It is the procedure aspect of the lower court and allowed, saying that they were not passed. So we have been informed that the degree is judgment is passed by the civil judge senior judge. So we applied the degree, and within a period of after obtaining the CTC certificate copy.
So where have you stated that in your petition? In your appeal?
Page, paragraph 10. Paragraph 10, judgment was, we have categorically, it's the 17/4/2018, we have received.
It says only received.
May I? It is my part, I have to submit. They can reply back, but later they can reply. I should be given full length submission first.
Yes, please carry on.
That is why paragraph 10 says, on 17 April 2018, I have received the copy and within a 30 days period, within the appeal period.
So according to you,
I
there
have
was.
filed appeal and the registry of the court is allowed, saying that it is within the limitation after verification of the court. So application was allowed without any application because court has, this matter was already raised before the court also. This is the situation. The court has accepted the fact that yes, there is limitation is not required because matter has been filed from the date of obtaining this CTC. It has been filed within the 30 days. Then if the matter is filed within the 30 days, where is the necessity of filing additional that unnecessarily file this?
Whether there in the judgment, has it said anywhere that since it was filed?
I can, that part, may I read? I'm reading the judgment of appeal judgment.
Yes.
Page number 126, annexure 14. Narrative.
Just a minute.
Ask another one.
Yes.
Kindly see. Para 124. There's page 134. Para 12. Paragraph 12. It says the learned court observed them.
Page,
Page-
para 12.
Para 12, page 134
Right,
of the appeal petition. For the purpose of computing limitation, time period for appeal against the decree is 30 days, and limitations run from the date of degree of issue. Be that as it may, kindly see, it is understood that it is 30 days. Be that as it may, the order recorded on, kindly see, the proceeding, this is reflecting the proceeding of the London Civil Justice Senior Division. 15 May 2018 and 28/9/2018 in the Federal Court. Nowhere indicates any objection giving rise by the respondent plaintiff. Respondent plaintiff. During the first and subsequent hearing, there was no objection. Hearing of the appeal, in the circumstances and under the provision of section 5 of the limitation, it is inferred that delay of 90 days, it is 90 days taken into preparing this appeal has been condoned. Generally, it is 60 days, but in the appeal it is 60 days. 90 days, maybe 60 or 90, it is condoned oral explanation made before the bar. Hence, the issue number 1 and 2 are decided affirmative in favor of the appellant. This is the issue. So, we have to fix the limitation issue. Under what circumstances, under what background, the limitation application for condemnation delay has not been filed. Why there was no miscase for limitation period? That was the issue. And this is a background fact. Under what circumstances this application was allowed without limitation, because that was so when there is no limitation period is required, not barred by the law of limitation, then the requirement, there is no requirement of some site issue saying that that is barred, it is not barred. It is immaterial. When matter is within the limitation, that is.
Yes.
My application was, certified copy was obtained on 17 April 2018. And it was applied on 2nd April 2018.
Where do we find that?
I have, this is my written argument. Kindly see, this is my written argument. Provided. On record, that is on record.
Written argument before this court.
Yes, I am submitting the written argument for the condition of the court.
there is on record, and this order in, just if you judgment in question before the, there's a civil justice, not civil justice, appellate court, district and sentence, it was 8 January 2018. And that is why here is an objection from the appellant that, this. Which paragraph you are reading, 8 January 2000? Which paragraph? My, it must be there. My affidavit in opposition. My affidavit on page 6 of my affidavit is opposition. The case is voluminous, but the issues to be settled is very only 2 issues. Kindly see paragraph number 9. Very detailed. Under
Paragraph
what
number
circumstances-
9,
Yes, paragraph 9, my affidavit, page 6, para 9. Page 6, paragraph 9.
Yes, this is
Ma-
your
ma-
affidavit,
ma-
of- this is
ma-
your
ma-
affidavit in
I am reading the contents.
opposition file.
File by me.
Before this court.
Yes, against this appeal, second appeal. Report. May I read the consent, this will reflect a clear picture. That the defaulting is the due course of trial proceeding before the civil justice senior division R of the Larat Court has closed the defense by order dated 21 August 2017, while rejecting the miss case number 31 2017, which was with a prayer for allowing to file a miss of witness. However, the Larat Council, Larat Trial Court has allowed the defendant himself as a defense witness in the case while fixing the case for DW on the date 21/9/2017. On the next, that is 21/9/2007, the representing counsel of the defendant could not turn as directed. So, the lone defense witness was also closed by the London court, and at the same time, the case was posted for final argument on 9/11/2017. Accordingly, the defending counsel made a verbal argument in the case on dated 9 November 2017, and the judgment was reserved. It was reserved judgment. Judgment was reserved without passing any order in the offense court. Since then, he has been waiting for the judgment and order of the case. So, to obtain the copy of the judgment, one of the defendant filed application on dated 2/4/2018 for issue of certified copy of the judgment dated 8 January 2018. Accordingly, he was supplied a copy of the judgment on dated 8 January, copy of the judgment 8 January 2018 on, kindly see, 17 April 2018. It was a reserved judgment. We are not informed of. We do not know when order was passed. We have court, we come to know from the court, or judgment has been passed. That is the case here. There should be fairness is as a matter. By the London Court Civil Justice Senior Division Allah. Further, the said judgment is without order C, separate order as per law and the practice. Therefore, it is likely that the said judgment has been signed on back date in absence of the representing counsel. In this connection, the representing counsel of the plaintiff, Sri Ray Boje, has applied the certified copy of that case in which there has been issued the copy of the certified copy on 9/4/2018. At the same time, it was a reserved judgment. Ray Boje also applied on this in like manner. Kindly see paragraph 10 again. I am continuing. The certified copy of the order. This I am arguing on that there's a limitation period. 17 April 2018 was it applied on 2/4/2018, as nobody knows that when the judgment was passed on 8 January 2018 was, and the judgment was passed in closed door without knowledge of the representing counsel. On personal inquiry, the staff is informed that the judgment has been passed on 8 January 2018 and they are brought out in the application for certified copy. The date of judgment has been indicated as in the judgment 8 January 2018. It was April and judgment was shown to be passed on January. It is the situation. Further, he states that after supply of the certified copy of the judgment on 8 January, judgment dated 8 January 2018 on, it was supplied on 17 April 2014. We filed an appeal before the district and session has passed by CBC on this one. With a categorical statement, with a category, what I have submitted, categorical statement in the paragraph 10 that the judgment was received on 17 April 2018 from the Court of Civil Justice Senior Division, West Island. As such, this appeal is filed within 30 days, which is under limitation time. Hence, the law of limitation doesn't bar. In the present case, the appeal was filed on 16 May 2018. It was within the 30 days. Appeal was filed before the district and session judge on 16 May. Certified copy was received on 17 of the interim order was furnished to the appeal 17. Considering the fact and circumstances of the case, on the basis of oral explanation made to the learned sessions court, Honorable Court was fully satisfied and convinced with the reasons cited by the appellant, and according to learned court did not reject the appeal on the ground of time bar. On the other hand, the respondent also did not make any objection over the admission of the appeal, except the irrelevant objection at the time of final hearing of the case. In this respect, the court may be called for perusal of the particular issue at the time of hearing if necessary. The humble deponent may be also to file additional affidavit suggestions. And this is the point. Fact. Under what circumstances the district and session judge has allowed admitted the appeal and allowed the appeal. This is the issue. It is the judgment that the senior division was it was never been pronounced in the open court. It was a reserved judgment. At belated stage, January 8 January was, we have learned January, February, March, April. It was already April 17. So after 30 days, court order was made public. It was the issue. So court allowed. That is why I am to say this limitation issue should not come before the courts of justice. This is some trivial issue, and that has this case on the merit as well as background fact has to be understood. Whether there is a that is why I am to say in the appeal application number, paragraph 10 is applied, and I have given categorical statement in the paragraph 9 and paragraph 10 of my affidavit in opposition, saying that it was a situation under which I have filed application at this appeal before the district and session judge, and session judge is admitted, verified, and when it is the application is not required for condonation of delay period. That is the issue. On that fact, I will submit the judgment also. That is there. And another issue, whether can I file appeal? Another second substantial question of law is, can I file appeal before the district and session judge without challenging the order passed by the civil judge senior
for rejecting my application for this filing list of witnesses. The issue is immediately in a hurried manner, this civil judge senior division has closed the evidence, whereas the issue is a very important issue connected with human dignity. Thus, lesser of case should not be won when by this technical. Then such lesser there is. From that side, also there is from this, although he is saying that he is a Nira, and from Nira side, there are many generations, and we will be branded as Nira slave. This is the issue. That is a very important connected with human dignity. So, I am saying the technical issue again. I am coming to that point. The London Court of Civil that district and session judge has remanded back. Why it is remanded back? My yes, if you know that. My affidavit in opposition page number 34. This is the impugned judgment of the district and session judge. From this judgment, we have to understand under what circumstances the London district and session judge has remanded the matter back to the civil judge senior division for fresh trial by taking fresh evidence. That is the issue. Kindly see.
Just.
May I see?
Yes,
Paragraph, this page, kindly see my page 46 of my petition, this affidavit in opposition of this case. Page 46, paragraph 17. I am reading from paragraph 17. Other pages are also important. Operating and reading operating. Can you see? This paragraph 17 says on page 46 of my affidavit in opposition. Mr. Taji Tajam strenuously contended that the London trial court did not erroneously deny the appellant defendant a fair chance to agree the witnesses for providing his case. He contends that appellant defendant was in a bona fide belief that his list of witnesses has been filed with documents on 15, it was 2014 matter, very old matter, 15 September 2014, before the predecessor court at Basel. But despite due diligence, the list could not be recovered from the records. Hence, he showed a chance to resubmit the list of witnesses which was denied. In his case, the trial court on the date 21 September 2017 pronounced the rejection order dated 1/8/2017 in miss case number 31 2017. This miss case, because I was denied, situation was I was denied from submitting this of witness. I have been ordered as well. So I have filed application, I should be allowed, but it was rejected. It was filed sub rule number sub rule 3 of rule 1 of order 16 of CPC for allowing him to file copy of the list of same witnesses, rather compelling him to get examined him as DW1. He was not allowed. This dependent himself was allowed as a DW1 on the same date of 21 September 2000, which he could not do so as his counsel did not turn up. Counsel was not even there. But court was insisting to proceed the further the matter in a hurried manner. Turn on
this day for pleading on his behalf. Consequently, order for closing of DWS. Again, then DWS was closed, was not proper. And against the principle of necessary justice. The rejection of the process in which the case was conducting was it was not in a proper manner, in a hurried manner.
Now, how that is connected?
Because at that point of time, because
That is not a question.
at the time, may I repeat that.
Mm.
At the time of defense side was going to submit the list of witnesses. Defense side has to show that during the course of trial. At that point of time, the list of witness was submitted by the defendant side was not available in the record. So the defense advocate say, I may be to give the list of witnesses because that is not available on record. It was a matter of only the 2014 matter trial was going on in 2017. 14, 15, 16, 17, 18, 19, 17. It was after 24 years. So at that point of time, counsel was even not there. The dependent side was there. Dependent that part was there. Who was called as Lira. That person was there. He was made as a DW1. No need any other witness supporting witness. So on that day, advocate again didn't come. All the evidence closed, defense evidence side closed. So as per it is a not only closing, but it was a principle of necessary justice. Rejection order is found to be intact in LRC, Lower Court report. Lower Court report that rejection order is clear. Under what circumstances that the filing of piece of witness is rejected. Again, paragraph 18, I am going to paragraph 18. Mr. Tajam further submitted, having agreed by the outcome of the Miss case number 31, that is rejection of list of witnesses, on 16 October 2017. The appellant dependent filed application registered as 54/2017. He again filed and then at that point of time, which was never been disposed. It was registered as Miss case number 54/2017, in which review application was filed. So that will be reviewed because it was technically wrong. So it was never been considered my application. Once I have filed this case for allow me to file in list of witnesses, and when that was rejected, again I have filed this case.
No, that
for-
how
because the-
that is connected there?
Because lordship, it is connected because the proceeding was going on. Kindly see that order application, that previous order was filed under the order 3 of order 16 of CPC, saying that I should be allowed to cite from my side witnesses, defense witnesses, because there was a title suit was going on, declaring my title as Nira. That was it. I should be declared as slave. I am not part of Bobo. That was the issue here. So, in the proceeding also, the learned magistrate was in a hurried and buried manner. No proper, I was not given proper time and proper hearing in evidence after evidence. That was the case. So, in this, as per the observation of the judge, and continue that when I review of the application with the rejection order of submitting this list of witnesses, that was never been disposed of, which was never heard. Here says Najib Tajam, the observation of the court was never heard. This application, Miss case number 54/2007, which is never heard and disposed by the trial court. Trial court on the other side, fairly submitted Miss case number 31/2017 is heard at length. Yes, it is. Previous cases heard at length, rejected the same same day in an open court and consequently upon which the appellant defendant was directed to be examined as DW1, as I have submitted. DW1 on 21 February 2017, which he has lost by his own default. The defendant was also rejected. Evidence of defendant was sole defendant was also rejected on technical ground. No evidence on the defense side. Kindly see, then I am coming down to paragraph number
Right,
20.
Counsel, kindly confine to the substantial question of law, huh?
Substantial question of law is there.
The next question
Yes,
is.
substantial question
you
of
have
that is, I am
completed
trying to
mediation.
explain.
Mm.
The second substantial question of law is that, kindly see. Whether first appellate court is rightly remanded based on method to the
Yes.
trial court.
Yes.
That is the issue.
Mm.
So, under, I'm trying to explain, under what circumstances the London trial remanded back the method to the trial court for fresh evidence. This is the issue here. Trial court has already remanded back a method to the civil justice senior division for fresh evidence. That is already pending here. That is why I have to say, under what circumstances trial court is remanded taken. Number one, I have not been properly given time. The proper time was not given in absence of my advocate on technical ground. Although that part, the only dispute was there in the paper, there is long pending file. Whether it was filed or not, it was not there. But when the turn of the defendant side for showing the list of witnesses on the record, the list of witnesses filed by the defense side was not available here on record. Then what happened? The defense side say, I should since the list of witnesses is not there, but there on my side there are many witnesses being examined. So he was seeking the court for examination of my side.
So the trial, plaintiff witness all examined already.
Plaintiff evidence already, everybody examined.
Okay, thereafter.
When my side was coming,
Your side,
none was examined.
Hmm?
None was examined. On technical reason, all my evidence has been rejected.
Okay.
Because I have not filed any list of witnesses. That was the deal. May I read the page number 47 is para 20. This is important part of them. Kindly see.
Para
20. Paragraph 20 of the imperial judgment. After careful perusal of the lower court records appears that application titled as Miss Case number 54, what I have filed later on again subsequently. That is 6 October 2017. It is found intact with the record. Paragraph number 2 of the application reveals that no speaking order was passed on 21/8/2017. In the contesting parties, the paragraph number 3 indicates that Mr. Bellier, the then lead counsel for the appellant defendant, was engaged in the additional district assessment class in the circumstances and also in absence of solitary evidence from the appellant, way has to be given to the order dated 21/8/2017 in Miss Case number 317. Had the appellant defendant obtained any certified documents pertaining to the proceeding of business conducted on 21/8/2017 in this case number 31, then this allegation could have been considered as valid. This solid documentary proof that presiding officer of the trial court did not pass the speaking order on 21/8/2017, except averment and oral submission made in the allegation has no force. paragraph 21 again. The learned trial judge, while disposing the missed case number 21, 2017 on 21/8/2017, paragraph 7 observed this. This is the observation of at that point of time what learned civil judge senior division is passed. I have prepared a report of it was fixed for filing lease of witness on 50 September 2014. And the defendant had not filed any lease of witness in the present case. The report, the order dated 50 September 2017 and 23 August 2014 passed by the landed legislative decision, the same should be relevant act or to such as that. So now I come to paragraph number 22. Paragraph number 22, page number 49 of my affidavit is over. The record transferred that the plaintiff respondent had submitted his draft issue on 2011. From plaintiff side, it was 2011 already. This draft issue has been filed. The draft issue of the defendant appellant does not bear filing date. No filing date was there when it was filed. More is there. The landed precision court has appended his signature on the issue when without assigning any date. More is there. It appears that the issue has been framed by the then first track court judge during 2011 and 12. Dispute is going on in the 2017. It was a 2011 and 12. Both sides did not file lease of witnesses. In case both sides did not lease of witnesses, then the order quoted herein abundantly revealed that only respondent plaintiff was specifically asked to file lease of witnesses. In that event, lease of witnesses on 15/9/2014. If that were the situation and the circumstances so prevalent during those days of court proceeding and practice, the appellant dependent ought to have been given a similar and fair chance to providing lease of witnesses by the recording regions for so will. By giving the appellant no prejudice would even be posed to the respondent. This 23. It is majesty of law which empowers the court to do justice to all litigants, even by vacating, modifying, or verifying its order, if necessary. Strict application of law is the rule, and extending leniency is an exception, depending upon the fact and circumstances of it. Dignity is more valuable than wealth and income. The appellant identity is under challenge, and unresolved crisis remains a constant losing self-respect. Reputation is image. There can hardly be a present issue than the legitimacy of man. The issue result, the issue number 4 is also decided affirmative in favor of the appellant and against the respondent plaintiff. In the region, the appeal was allowed with observation. So I have to say, because one is that why this matter was remanded to appeal after allowing the appeal, remanded to civil justice because number one is appeal number that is a review petition in the form of IA. Review petition number in the form of missed case. Review petition number 54 of 2017 was pending before the appellate court on record. Even then, although this review petition number 54 for reviewing that filing of lease of witness, rejecting the application of lease of witness, that was there. So without hearing that lease case, in a high buried manner, the London senior division passed an order, this dividing this challenging this setting aside my affidavit. I have issue is that I have sworn an affidavit before the judicial magistrate saying that from today I am the biological son of
Vasobobo. That was there. That has been silent, saying that you are not the Bobo, you are a Mira. You are a slave. That was there. So when this miss case number 54 2017 was not disposed of and the order was passed, that is also that has to be looked into that. And as per the landed code of the appellate court also saying that this of trial, this matter looked into by the civil judge senior division. And matter, only the observation was that matter required relook into the matter, fresh evidence is required to decide the legitimacy of the person. It is connected with the dignity of the man. It was the issue. So, in terms of that, remanding the matter, that issue, suit number 17, remanding the matter is miss case number 31, order dated. That was what has been raised. The issue raised by the appellant before the second appellant before this court is since in terms of the number 31 2007 order dated 21 August 2017, when the appellant has been already debarred from filing list of witnesses. In that situation, the appellant has no right to file appeal. This is the issue. Point of time, the Honorable Civil Justice Senior Division has already disposed the whole matter. All the judgment has been passed. In that situation, that order dated 21/8/2017 of miss case number 11/2017 has already merged with the final judgment because all interlocutory orders merged with the final judgment when the final order is disposed of. So the appellant filed the appeal before the appellate court, first appellate court, saying that this and that thing has happened. So that is already merged with the final order. Why I should appeal? And there is no judicial tool. When already matter is out from the court before the civil senior division, because final judgment is already passed. Even that judgment may be his side or my side. So I have agreed with that judgment. Harif judgment. I have filed an appeal and court was leniency was given. Court was justice was given. Observation was given that human dignity is more than anything else. This matter required to be, and there are so many technical issues, background fair. So matter required finding this finding hearing with producing sufficient evidence from the defense side as well. In that aspect, I am one judgment only. Technical, my judgment is kindly 2010 6 SCC 553 paragraph 5, 6, 7 and 8. In this judgment, Honorable Supreme Court double bench has said that just travel technical issues should not come into the courts of justice. The inherent power of the court can discuss just technical issues to do the justice. May I read the content?
Yes.
I'm reading the paragraph 7. I'm reading.
Do you have the copy?
Paragraph 1. I have what is submitted before that order. Even
Yeah.
after this year.
This is case.
Case is my
Pertinent
pertaining to this technical issues.
party name.
party name is Amrit Lal Kapoor versus Prasun Lata Kapoor.
No, it's not available.
May I read the content? This is a ratio decided in this case. Lordship, this technical, mere technical issues should not come in between the course of justice. This in court can apply inherent power to do justice. This paragraph 7 says, there is a considerable merit in the submission made by the Mr. Agarwal Silencer. He is an attesting witness to the will, which the dependent appellant herein have set up in their defense. Non-examination of the side witness would therefore seriously affect their case. We cannot lose the sight of the fact that witness would not be produced, not because of any deliberate or neglect or inaction on the part of the appellant herein, but on account of the refusal of casual and station leave paid by him in the circumstances in the interest of justice would be substantially served if a final opportunity is given to the appellant to produce their witnesses. In the result, the appellant is allowed the order passed by the High Court and passed by the trial court are set aside and matter immediately to the trial court in the direction that the appellant shall be permitted to produce Mr. Ashwani Kumar Kapoor as a witness in support of the case by assuming by someone directly to the witness, also though his immediate officer, service of someone shall be the responsibility of the appellant. We further direct that since the order closing, this is also a similarly situated case. Order closing the evidence of the appellant has been set aside by us. The appellant shall be free to examine any witnesses, any other witness in support of the case who is cited in the list already filed by them, but who has not been produced so far. The production of any such witness shall, however, be the parties with their own code. So, this is my code. I have submitted, but that may be taken under code. I have already oh yeah, this is there. This may be taken. And go. The text and close the copy. Order given. So, in my case, this due to technical reasons, I have not been allowed additional division. Although the issue of the declaration of title is a very coercive, very harassing, and this is lowering my dignity in social life. So, this Federation Court, the court below has already not only passed the order, but also passed the reasons for allowing the order. So, it is my prayer, matter maybe, since matter has been already remanded back to the by the district assessment as concerned, matter maybe instant matter may be dismissed and party may be allowed to report with the senior division so that they can find the matter of merit that will subserve the interest of justice. That is my comment.
What I'll do is I have some other matter, I have CAV. So now what I'll do, take it for just for further hearing. If
Yes,
there's-
but I want to reply, man.
Yes, so for some clarification from my side also it is necessary. So we can keep.
I have
one
never
more-
heard anything like this. Almost 1.5 hours, nothing on the question of law. This is second appeal, madam.
Yes, yes.
I want to reply, madam. Tomorrow, day after, I want to reply.
So Thursday or
Thursday.
let us see on Thursday.
Yes.
A second appeal, my lord, it is the appellant, my lord, who is in a very hard place.
Hmm.
This only when there are substantial questions of law, your lordships allow it.
Hmm.
After considering my second appeal, this honorable court came to a conclusion that there are some grounds, substantial grounds, there are two questions.
Hmm.
We're supposed to be arguing that, my lord.
Okay.
There can be no argument advanced on merits, my lord, here. I would
Yes, yes.
like to reply, my lord, Thursday.
Yes, okay. So,